Court of Appeal declined to suspend the bench, which is expected to deliver a ruling whether to lift the conservatory orders prohibiting the swearing in of Kindiki or not. Now, Judges Patrick Kiage, Agri Mchelule, and George Odunga ordered the matter to be heard virtually on the 6th of November. Gachagua had moved to court to appeal, seeking orders to declare the bench appointed by DCJ Mwilu as unconstitutional. Of course, this is another case that he's lost in the corridors of justice as he seeks to fight to save his seat as the Deputy President of the Republic of Kenya. Here in studio, I have two guests. Of course, later on, we'll also be joined by Robin Karani, who says he's on his way, so you're waiting for him. But right now, I do have Kimani Mwangi. Thank you so much for making time.
Asante sana, Brian, for inviting me.
Yeah, you say it's hot today.
Yeah, it
is it because of what you're expecting in the corridors of justice?
It is hot physically and even symbolically.
Symbolically. All right, Mary Ariviza. Hi, Mary. It's been a minute. Yeah, it has been a very long minute. Thank you so much for making time today.
Thank you.
All right. I want us to start with what we expect, of course, and the events that have led to this particular case today and what we make of that. Let me start with you, Kimani.
Yes.
Of course, the Deputy President, that is impeached Deputy President Rigathi Gachagua, taking to the corridors of justice was in order to be able to seek justice for himself and this particular, in this particular scenario. But to some extent, we've seen most of the attempts that he's been able to make have been hitting a dead end. When you look at that, does it somehow paint a picture on what the end could look like?
Firstly, it is good to point that courts try as much as they can to be in keeping with the doctrine of separation of powers. Impeachment is a constitutional function of the Parliament, in which case, for us, is the National Assembly and the Senate. So what the courts would try as much as possible is not to seem to interfere with a constitutional function that is allocated to an independent arm of the government. Because if they did so, then they would be doing what we can call as judicial bullying. We have experienced dictatorship by the legislature, trying to dictate things that are even done by judiciary, disobedience of orders and such like stuff. And the court being the final arbiters of law, they would try so much not to emulate the bad manners of legislature at some times. And that is why you realize any judge giving orders or instructions must be very careful as to whether to give or not. The only time at which courts are allowed to intervene is when there is glaring violations of the process or even glaring violations of the constitutional rights of the impeached. In which case then it's a matter of argument. Okay. Because glaring means that it is so clear that any reasonable person can tell there was violation of process and then there was even violation of rights. In this one, remember that it is the High Court that dictated how the public participation, which is one of the main things the Deputy President decided on, should be conducted, from the county levels where it was being conducted to constituency level.
Okay.
Now, also,
on this issue of public participation, though, there's no, because several, even the Finance Act 2023 ruling, I did say there's no proper mechanism in conducting public participation.
There isn't, because
that will then guide how do you make a ruling on the issue of public participation. Because if I engage the two of you, at the end of the day, I'll just say, yes, the public was included in this particular exercise.
There is a public participation bill of 2023 that the Parliament hasn't made into law. And this is to the misdoings of Gachagua for now. Because it would have been the procedural law that would have guided the process of how public participation should be done, based on which you can ask the judge to find that this clause and this clause was not, we didn't follow this and this clause. In absence of such procedural law, the judges can only follow interpretations that have been done, or what we call precedents. There is now the general procedure set in the Constitution in Article 10 and 118, and there isn't much they can do. Whatever else you raise is an issue of argument and counter-arguments by both sides. And the other thing that they have been raising is the fact that the deputy president, former, was not given a chance for hearing. But again, the constitution is clear that you can represent yourself or be represented by the councils. Okay. He was represented by the councils. Again, there is no clear telling that again the rights of the former deputy president were violated. He was given the chance, he never showed up, he was sick. You cannot attribute sickness to any of the parties. It is a natural occurrence. So then it would be upon the judges to decide whether not waiting for somebody who had fallen ill and without clear guidelines on when he would be back to take the stand, whether it is a violation. Okay. In as much as there were lawyers with his instructions to represent him throughout the entire process. Okay. So those are issues where there is no clear violation, and then the judges would not want to interfere with the functioning of the National Assembly and the Senate, and I would believe that is why out of over 30 pleas by the Deputy President, nearly all of them have been disallowed by the judges, including the one at the Court of Appeal, to find that the three-judge member bench is sitting illegally. The Court of Appeal said they can't allow that order.
Now, that's the thing, because you see, and that's the question that I asked earlier, that most of these attempts to be able to get justice seem to not bearing any fruits from what we are able to see, and even from what you're mentioning, because he has a case, but when you look at his arguments, you say there's no clear way to actually point out that your case is strong or not to some extent. So then what would that mean for the entire process? Do we look at what we are experiencing at the moment to be able to judge what will happen next?
In my opinion, I honestly feel for the Deputy President, because the issues he's pegging on for his survival are issues I wouldn't want to find myself pegging my hope on. Okay. Public participation, as I've told you, there is no clear ruling on public participation because it depends on how you argue. There is no procedural law that gives guidance on how it should be done. Now, when you take it to the judge, well, there was public participation done as instructed by another judge, then that is tricky. Now, when you talk of your right, impeachment is more of correcting an error in governance. It is not about punishing somebody. Okay. It is not about your rights. It's about somebody who occupies an office but does not meet the standards or the thresholds of a person who should be sitting in that office. Now, such issues, and you see they are not touching on the grounds so much. And again, let me tell you, the grounds are even the worst. Because the threshold of these grounds, they are not criminal grounds. So the threshold, or what we call the standard of proof, is not beyond a reasonable doubts. It is clear and convincing. While the threshold for civil cases is a balance of probabilities, very easy. Did it happen? Is there any probability that that happened? That is very easy to prove. On crime, it is on beyond a reasonable doubt. You just don't condemn somebody on crime before you are convinced beyond a reasonable doubt. But now on impeachment, which is an administrative issue, the threshold is simple, clear and convincing. Now, if the judges find it clear that Gachagua propagated a narrative that Kenya is shareholding, and that those who did not vote should wait for those who voted to it for them to be given something to it. And remember that even these judges, much as the requirement is that they should be of an unprejudiced, reasonable mind, there are also people coming from these regions that were told they are lesser shareholders in the company.
We are hoping that that is not going to inform,
to inform how they do. There are things I wouldn't wish to find myself arguing to convince people that I told are not shareholders in this government. I wouldn't.
Mary, let me come to you. The Deputy President, and just as you comment on what we have been able to experience in the corridors of justice, the kind of defense that is given since day one in terms of what we've been able to hear as far as his cases are concerned. What do you read into that?
I think he's traveling on a very tight rope, and I think Mr. Mwangi has so well put it. The fact is, you cannot go to the court and you also say that the Deputy Chief Justice cannot be able to constitute, and yet in their work, they are supposed to do such, you get. So you lose it even before you start, because the Chief Justice, in the absence of the Chief Justice, or when the Chief Justice doesn't want, because Kindiki happened to be coming from, and Kenya is tribal, Kindiki happened to be coming from where the Chief Justice is coming from. So for her to give the Deputy Chief Justice to constitute the bench, it's very okay. Because the way probably they have seen is that the former deputy president would have come in and said, again, it's because Kindiki is coming from there. So she left that. So for you to come and say again, that bench is unconstitutional, it doesn't hold water. I'm just saying that he's got a right of appeal, he's got a right of going to court, but it's again a non-issue. Secondly, I think Mr. Mwangi has also said it, is that the parliament or the legislature has got a right of doing exactly that. And that is one of their duties. The parliament and the Senate, they have a right of doing that. And it is very well spelled, if you look at the constitution, on what should be done with the deputy president, or the president first, the deputy president when there is impeachment. So what I see is possibly he would have gone to the constitutional court to say my constitutional rights were done here, were not followed here, and not followed. And I think that's what he's trying to do by saying that there was no public participation and that kind of a thing. But as far as the parliament, both the Senate and the parliament is concerned, the right of what was done for impeachment is done. And it met the threshold of two-thirds majority. In fact, I think overwhelmingly so. So whether there was inducement or no inducement, it doesn't hold water, because he has not also brought those evidence that was such. All we are doing is rumors. So the parliament did the right thing, and as Mr. Mwangi has said, what the judiciary is doing is to try and show that, to reassure that his rights were violated, which he has to prove that they were violated. The constitution also was not followed. That's only the only thing he has. But as far as parliament is concerned, they did the right thing. So I think he's really on a very tight knot. And then the judiciary wouldn't like to look like they are interfering also with the legislature.
So where do we draw the line on the issue of interfering with the legislature? Because you say the parliament and and the Senate do have their constitutional mandate, and that's why conservatory orders were not being issued during the impeachment process. They're like, okay, let's finish in the National Assembly, in the Senate, then from there we get into what will be happening now in the corridors of justice. So if something the impeachment process, when you look at the Constitution and say the Senate, once you're impeached at the Senate, then you stand impeached. So that is final. That is final. So then what will be the work of the corridors of justice? So you move to court if at all you're dead, your fate has already been sealed.
Okay.
No, my take would be, court solves legal problems. And being the final arbiters of law, anyone who has an issue, because there is what the lawyers would call that you can suffer prejudice if the judges do not find that if the judges do not intervene or the courts do not intervene, if there was an I'm trying to look for the best word. If there was an infringement of your right, so to put it, and if it is allowed to stay. Firstly, it set bad precedents, and number two, you suffer prejudice as a person who was subjected to that process. So the only, like I said, impeachment, by the way, is both in content and merit purely political. that is one thing we must understand, that it has got, in content and in merit, it is purely political. It solves a governance issue. But then, even the impeached have a right to a fair and to what we call the rules of natural justice. If you must impeach me, then let it be as fair in the eyes of law as possible. Now, what the impeached is doing in courts is to ask the courts to find whether he was treated as fairly as possible in the eyes of law, or whether there was prejudice in the entire process. If the law demands that there be public participation, was public participation done in a way that the impeached is not unfairly treated?
Okay. If the impeached
should present himself and argue his case, and he never got that chance, can the courts find whether by his not having that chance prejudiced the process, or in any way made there to be a verdict that would have been otherwise if we had that chance to argue his case? But then, as I told you, it is a matter of the accused or whoever alleges must pledge, must prove. If you come to court and allege unfair treatment, then it is incumbent of you to prove that unfair treatment. And that is why the burden of proof now lies with whoever went to court to complain. Then you must prove beyond or clearly, in a clear and convincing manner, that the process was entangled in prejudice, and that you are not treated as fairly as possible in the eyes of law, as a result of which you seek to have your office or reinstated in your office, so that if whoever impeached you feel that they still have to impeach you, they wait for another 6 months and now do the things the right way and now impeach you procedurally.
So what happens when, with this particular argument that the decision made at the Senate is final? If at all you go to court and the court says, okay, the process that was followed was a little bit flawed, do we now reinstate you back into your office? What happens? Separation of powers, like you put it. You see, we have the judiciary, we have the legislature. Which one is interfering with what?
You see, like I told you, courts do not solve political problems. If we have political problems with you, we can solve them the way we feel like, as long as we are within the principles of law. If courts find that the process was faulty, or the rights of the impeached were infringed on, they have a right to give you back your office and tell the political class you did not do your job as you should do in the eyes of the law. If you feel like, repeat it, but do it. We have no argument as to whether you have a right to do it. Okay. But if you must do it, then do it rightly in the eyes of the law, because judges are the custodians of law. All right. So they're the ones who interpret it, and they're the ones who tell us whether we followed it or not. Okay. If they take him back, it is not upon them to allow them to live together. That is a political problem that the two gentlemen, the president and the deputy president, will go solve if the deputy president is told to go back. Now, what we are witnessing, the hurried process of having the deputy president nominee sworn in, is because the president wants to have a person he feels, this one I'm unable to work with, I need somebody that I can work with. Okay, so there's a political process. Like you say, the courts are not solving a political problem. But at the end, whatever judgment is going to be made, if at all it is in favor of the deputy president, then it gets to interfere with the political problem. Yeah, it does. How do you balance that? If because and there's been this argument that if at all there's a judgment in his favor, and we say, okay, now we are able to reinstate you, and because the process was flawed and all that, what will happen politically, if at all? What happens in that particular front?
Well stated by Mr. Mwangi is that it's a political process. The impeachment is a political process. However, I think we Africans have to come to terms with being able to resign. You know, when you resign, when you resign earlier, like we have now learned about the brother's widow. We wouldn't have learned about it. We have learned about the 3 billion while you were at not even a billion when you came into office. You know, when you resign, you cover up many problems. The Bible says that love covers up a multitude. But I would say when you resign, it covers up for you. We have to come to terms that not everything must be fought for. And I think it is a thing that we the Africans especially, where we have to fight, I'm going nowhere, and you have the backup of your wife and your family, it doesn't work. Because at the end of the day, you are fighting to remain in office. You are saying that the person who is your senior is vicious. How will you work with a vicious person? That kind of a thing. So the best, I think, would have been to resign. And
but
resigning, it's good because this is something that is likely to happen at another time. It's important for us to educate one another. Resigning does not mean you are defeated and you are evil and you are bad or what. Resigning just means the way it is irreconcilable. You know, the way a wife and a husband goes to court and say the reasons why we are doing this is because we have irreconcilable differences. Because apparently we have learned about many other things that happened over a year ago that had not come up. So if the person had resigned, it would have just been silence where you are respecting one another, you go and do your thing and what. So anyway, we are beyond. This beyond is quite a difficult beyond. For the deputy president, a former deputy president, because we already have a designate deputy president.
Do we call him former now?
Yes.
Yeah, he is former.
He is former.
Okay.
He's former because we have the one that is dead. Is designate. You know, when you go appealing and you haven't been proved, okay, I know people can say that since the court are still saying, but the courts did not say that. They have done, all they are doing is to show for him not to be sworn in. But I think he's a designate. Designate is not yet. Okay. Yeah.
So do we have 2 deputy presidents, or do we have a former deputy president? What do you have? Well, sorry. Welcome to the show. Thank you so much for making time. And I hope you're driving, and is it 80 kilometers per hour? So yeah. You're safe, right? Yeah. Thank you so much. Robin Karani joins us tonight, this afternoon for this conversation here. We are glad to have you here on set. So my question was, where are we as a nation? Because some people will argue, unless he's sworn in, Rigathi Gachagua is still the deputy president, then your colleagues here say we have a former deputy president and a deputy president designate. So where are we?
That is a matter of law interpretation. And you would have seen it in court where the 2 sides were arguing. Because one side argues that the moment the Senate passed the motion to impeach the deputy president, then he ceased holding that office. That is the argument of the National Assembly, the government side. Now we have a different, the adversary on the other side who argues that now we went to court and we were issued with conservatory orders. And by virtue of those conservatory orders, we still have the deputy president in office, and that is why you cannot swear in the other office, the other deputy president. Now you would realize that even in the case itself, I don't want to call him former, I don't want to call him deputy president.
Call him DP1.
I just call him, yes, DP West. Yep. So DP West. DP West argues that
if you go with DP West and DP East, you see we have different sides of the mountain. So it's a little bit, but anyway. Okay, so.
Anyway, that's what I was trying to avoid, but it has come anyway. So I'm saying DP West argues that at the point of appointment of DP East, he was still the CS for Interior. He was not a member of UDA because he had to resign to be in that state office. And so he would not, so the political party registrar was in error to say that he's a member of UDA and that's qualifies to be nominated for that political seat. So in both sides, unless the court comes out and declares itself on that particular matter, I would not be right to say that we have 2 deputy president or 1 is former.
So the state of the presidency and this vacant, the seat of the deputy president is dependent on who you ask at the moment until the courts declare, pronounce themselves on this matter.
You know,
what about the gazettement?
For the layman, they say we are on shuttle mode. That kipanda matatu yenye haina makanga, hiyo haisimami kwa njia, inaenda ikienda. So that's where we are as a country. I would, if I say that I support, if I call the deputy president the former deputy president, I immediately become his adversary and I am from pro-government. If I say that Professor Kindiki is not a deputy president designate, then I officially become a chief villager somewhere. So
so that we don't spread, because you see, and I think this is one of the subjects of debate in the country, where people are a little bit confused on where exactly are we. And to some extent, with that, there's a lot of misinformation that is spread around, whether we still have a deputy president, he's no longer in office, he stands impeached. That was something, actually, how we put it, that was argued in the corridors of justice, that you were out the moment the Senate pronounced itself on this particular matter. That was done with, we were done with you. But right now, if at all, I'll argue from what people have been very concerned about on why we need to, swear in the deputy president designate, or East, like Rodi puts it. What will happen if the head of state was not in the picture, maybe travel outside the country and all that? Who then becomes the person that is in power at the moment?
Now, there's that notion that Kenyans have been having, and I would say it was a mistake done by President Uhuru Kenyatta, that you leaving Kenya does not make you not president of Kenya. It doesn't make the deputy president the acting president. It is just a political say. The manner in which you can have your deputy assume office while you are incapable is when you give him to him and he's sworn in as president. Okay. To that caretaker point. Now, President Uhuru was in a position where he was summoned to the ICC to go before the International Criminal Court. Now, to go there as the president of a republic is to give away the sovereignty of that state. So for President Uhuru, he chose to give that office to his deputy to hold so that he can appear before court as Uhuru Kenyatta and not as the president. Uhuru Kenyatta, the president. So from that moment, I think the political narrative has grown over time, and we tend to assume that whenever you see President Ruto out of the country, then by default, Rigiji is the president. It is not the case. Okay. And there is no vacuum. In fact, the office of the deputy president, other than holding IBEC meeting and those specific ones that he had been given through the executive order, basically does what the president says. Yeah.
Okay, so, but you see, in 2023, during the Maandamano, and I don't know if you took part in that, but in 2023, during the Maandamano, when most of the time the president was not in the country, and one person that will wake up at 5 a.m. and say, I'm the man in charge at the moment, was the deputy president. So to some extent, and that's where the narrative came in, that you see, when the president is not around, if at all he has to leave the nation at this particular moment, he has to leave it in the hands of someone. So what you're telling us at this particular moment is that the president can leave the country with all this that is happening in the corridors of justice and the political space, and we wouldn't feel the need to have somebody in charge when he's out.
Yes. That is exactly what I am telling you. The work of the deputy president, according to our constitution, is to be the principal assistant to the president. Basically, to be KYM. When you go to political offices here, you will find so many people who call themselves PA wa Mheshimiwa. And they're the ones who come to Harambes with money, with bahashas, with messages from Mheshimiwa. That is the work of the deputy president to the president. In as much as they're elected together, that is what he does.
That is what he signed.
That is what he signed.
He's a helper.
Yes.
No, he's a glorified KYM.
Okay. I want us to look
and
at...
I think Mr. Mwai is, and that's where we are, where we get into a social quagmire, where somebody doesn't recognize their position, their responsibilities, and follows them. I think at one time I have had our former, I will allow me to call him former personally.
Now we know which side.
Our former deputy president said that when he went to the elections, he was actually chosen by Kenyans. The thing is, before President Ruto said, I have chosen Rijdi as my whatever, nobody was going to give him as per that, although I'm sure he came in with, to be fair, he came in with votes. Okay. But, so you need to know, you actually are acting on behalf. And I think this brings me to, I think it is Article 1 of Kenya, where, is it Article 1 or 2? You will correct me. Yes. Of our values, I think it's 6. That's 10. Article 10. Article 10. Yes. Article 10, our value system. We need to have our values really inculcated in all of us, where we honor and respect offices. I don't have to like the president, I don't have to agree with him, but once he assumed that office, it's important that you honor and respect them.
That turn out to be quite a debatable issue. It's not
debatable. Values. Honor. Honor does not mean you agree.
So now Article 10 gives us a number of national
principles and values.
Yes.
Of governance.
Like for instance, one of those values is unity. The presidency is supposed to be bringing this country into national unity, which we have not been treated to in the last few times. So if the court, for instance, decided that the former deputy president should still be there, it will really disorganize the whole country, especially on matters of unity, which is so important in this country.
So one of the other values on that, on Article 10, is public participation. And one would argue that we have 4 vacant seats at the National Assembly. So the members of those constituencies were not included in the decision to impeach the deputy president. One would also argue that for Kindiki to be appointed, there was clearance from IEBC, there was clearance from the Registrar of Political Parties, and all this was done within 6 hours at night, and no public was involved in that process whatsoever. So if we come to the issue of the national values, it brings about a whole debate depending on where you are standing from.
Okay. But values on that, I would say it depends. I think you came in a bit when he had explained on these things of public participation. Some people can argue that public participation starts at the constituency level, even ward level, and those kind of things. But somebody can say that the meeting that was held at Bomas, for instance, Bomas is very well known for national issues, was enough, and it stands enough for public participation. Because anybody that is of national importance, whoever you are coming from, whichever area of the country, you can be able to come at Bomas and be able to participate and give your views.
And I think that maybe before I come to you, just through this to Robin on the issue of public participation, because what Kimani had said earlier, there's no clear law on how public participation is supposed to be conducted. So what will, and we also saw in the ruling by the Supreme Court on the Finance Act 2023, because from the High Court all the way to the Court of Appeal, the issue was that there was not enough public participation. How was it conducted? Were the views of Kenyans actually taken into consideration? But we get to the Supreme Court and you're like, okay, so you don't have to prove that you actually took into consideration the issues that Kenyans raised during the public participation, quote unquote, but you just have to show that you did carry out public participation. So what would then be public participation? Because, and I think this is what Kenyans are grappling with at the moment, whereby people will be like, tulisema kufa dereva kufa makanga. We said no to the Finance Bill 2024 during the public participation exercise, but our views were not taken into consideration. So what happens in that particular front? So what is this public participation? Is it just, what is the word? PR? Do we just do it because it is in the Constitution and we say we need to do it? But how do we get to measure this public participation exercise?
Brian, let me start by saying that we have had this conversation with you for a long while now. And even before we were on this platform, we were on other platforms just speaking about this. And one of my suggestions, which was taken up in the BBI, was when we proposed to come up with the office of the public participation rapporteur. And the idea was that we do not have a threshold for what public participation is, that we cannot quantify the input of public participation. If you go to the UN Habitat right now, they just had the assembly, the UN Habitat Assembly 2, just a couple of months here. And the theme for that time was meaningful participation, that we need to move away from just calling it public participation to actual meaningful participation and engagement, that you need to understand. So why is the public interested in this issue? What is their view on this issue? What can I do from this issue? And from the policy idea that we are bringing to the table, how does it affect them, and what do they feel about them, and how can we come to a middle ground? Now that has been missing. When Sakaja was a senator, he brought about a bill called the Public Participation Act. It was full of very many gaps and not creating that room for that office. Because what needs to happen is that there needs to be a specific public sector from the national government that deals with public participation, that then brings it to the CS responsible to have regulations for public participation, so that we can have a process, a procedure, and ways of measuring what actually happened. Because when you come back to issues that really happen on the ground, the counties at the moment, everyone relies on their own way of doing public participation. Here in Nairobi, we do public participation at the sub-county level. So it is held in one ward, when there are 5 or 6 wards in that specific constituency. And so when you do it in Ward A, all the others will feel left out from that particular process. So in that legal drama, there have been 2. I would not say there is no law per se right now because of the ruling in the BBI case. And we had the ruling before that.
The Sonko, the Sonko impeachment.
So
but then
we had 2. Just a moment, I comment on something that people are seeing on the screen. Of course, live pictures are from the Milimani Law Courts, where the judgment is supposed to be made this particular afternoon. Of course, as you can see, they are counsel for the petitioners, and we've been able to see Degwanjiru there, and also John Haminwa, 88-year-old. I think he's the oldest currently right now. Looking up to him, of course.
Doing very well.
And so, those are live pictures from Milimani Law Courts at the moment, as we await the judgment whether to vacate the orders of proceeding with the swearing in of Deputy President Designate Kithure Kindiki. All right, Kimani.
Yes.
Yes.
No, if I may interject on public participation, the catch-22 situation in public participation is especially on oversight functions of the parliament. I like giving a scenario. Say, for instance, I went to visit the president and we had a quarrel, and he really clobbers me and I die. And now the president, because he cannot be sued, has to be impeached. Do we go to ask the people whether we ask the president who's killed Kimani, or should we not? Now, in other words, I'm asking, should we be conducting public participation on oversight role of parliament that has pure delegated power from the people, as it is in Article 1? And then when we talk about public participation, there arises a question. Assuming we even, as the former DP I like calling him former DP because in my opinion he made political mistakes he shouldn't have made. And as a result of which I have no kind words for him. Now, the former DP tells us that we have an issue with this public participation because people are told about my charges, they were not given my responses. Yeah. Makes a lot of sense. But then you ask yourself a question. Public participation is not quasi-judicial. The people do not have the ability to interrogate the response and tell that you lie. If, for instance, your response is a lie, how are the public to interrogate it? And I think that is why there is, it is a requirement by law that the Senate sitting be quasi-judicial, because at least Senate can have that ability to hold the sittings to investigate the both the charges and the responses and decide on them. Right? So the public participation issue is one that is such a broad topic, because where do we draw the lines? Again, if public participation said in clear terms that we don't want the deputy president to be impeached, but then the National Assembly has content or cogent grounds anchored in law that he has breached, that there is gross violation of the Constitution, assuming there is one, there is gross misconduct on his side, and there is serious reasons to believe that he has committed a crime, both nationally or internationally. And these are thresholds upon which a deputy president or a president should be impeached. So which one reigns supreme? The whims of the people who feels this is a person or you are evil, more evil than him and he shouldn't go, or the National Assembly sitting and finding wrongs of this deputy president. And that is why I said, and Wakili would agree with me, this is now where the courts come in place. At the court, we expect to meet very wise, reasonable, and prejudiced minds. And that is why part of the requirement is that you should have worked for over 15 years for you to be able to sit there adjudicating on these legal issues. But then, you have to clearly and in a very convincing way prove to the judges that there was prejudice on this side. So, in my opinion, public participation is such a broad topic that I wouldn't wish to find myself as part of the reason I've dragged the people to court so that they can find a favor in my prayers based on public participation. So
does then the issue of, because that is one of the arguments that it will actually play out in the corridors of justice when it starts, the issue, the hearing, especially on the impeachment part. Do we have a case? And I know, depending on which side you defend, you have to be able to put up a case. But being objective and just looking at what has been able to play out in the corridors of justice, from the political front all the way to what we are now witnessing in the corridors of justice, and what the petitioners are, depending on to be able to put up a case. Do they look like they have a case?
Okay, let me start by doing a quick rejoinder to my colleague on the panel here. And he talks of, he gives a very good scenario of the things that he thinks we should not include the people when it comes to impeachment because they are outright. And
no, because they are oversight, not outright.
not even the oversight part, but being is so obvious, like the president killing a person. And,
just an example.
Yes, just an example. I'm just saying that if you come to the actual people, the level of people and dealing with policy, you will find out that the things that you call impeachable are very relative when it comes to people. And we are dealing with a government that got in here through the Bible. And I don't want to be the prophet of doom, but someone might remind you of the story of David and Uriah and tell you that at the end of the day, David was a great man in the eyes of the Lord, despite what he did on that particular time. But moving on, you asked a very good question on this matter of our deputy president and if we have a case. I want to point that it is very of grave public interest for Kenyans and for everyone at large to see what we can, the level at which we can give our impeachment of a deputy president. It is quite our laws give it for us to be mandatory, that we deal with jurisprudence, we deal with precedents of cases. Okay. So if this case goes in a certain manner, it will create the pathway for the next and the generations to come. Okay. So if you want to tell the general populace that you can impeach your deputy president because you have differences with how much money he has, or the way he dresses, or how he appears, or he doesn't look smart enough according to your eyes. If that is the bar you want to set, you will just have to live with the fact that that will be the bar set for the years to come, even for the people who will hold that office when it comes to text. It means that when you are a deputy president dealing with a president who can marshal the numbers, you are even afraid to speak of yourself, because you might say something. If the condition, if the standard is based on your utterances in public rallies, then it would be, for you as a deputy president, you are very careful not to cross your words with your deputy president.
And that is important, and it should be. All over the world, look at the US. I keep checking out on the one who, the outgoing president, and the Harris. You didn't hear much of Harris before, and even now the president of the US, when he was deputy, you did not hear much of him. When they were with Obama, you heard more of Obama. You can't outshine your boss. It doesn't matter. Even the Bible says this. If they are reading the Bible, they better know that the Bible says that you cannot be bigger than your master. And honor, and I started it by saying, in this country, we must inculcate in our children and the future generation honor. And when I honor you, I don't have to like you, I don't have to respect you. And the president office is very important, and it should be honored. If you don't respect
someone, how do you honor them?
Yeah?
If you don't respect them, how do you honor them?
If you honor and respect goes together. When you honor a person, you respect them in spite of what they are. When I don't have to like President Ruto, I don't have to agree with everything that he does. But if he chose me to be his deputy president or running mate or whatever, I have to honor and respect him. I cannot go, he has given, and worldwide, there is no way a president will give a speech and a deputy goes on TV.
So I'm just
what
curious.
We are saying is,
I'm just curious.
No. I'm answering on the fact that you said that we may be setting precedents.
Yes.
I know in law, I'm not a lawyer. I'm a social scientist. But I'm also a student of behavior. I'm just bringing in, I'm a psychologist. I'm just bringing in, you cannot do some things just because you are a deputy, you brought in. No, you have to honor the person that has called you to work with. And even if you don't honor them, you may go in the bedroom, as it were, in court, and quarrel in the boardroom, the two of you, that I don't like the way you are doing things here and there. But the public must not know. I think our deputy, former deputy president, that is the wisdom he did not have. And the Bible is very clear. You can't have your wife also coming around, ganging up and saying, my husband is going nowhere. But
there is such a case in the Bible.
Where? Where the wife is saying
what was the name of the guy? Nabal.
Nabal.
No, there's this woman who runs and meets David and says,
yes,
my husband
Abigail.
is very stupid. That was not a good one. I was saying to Wakili, the Constitution has made it that those who occupy public office should be held in very high esteem. And that is why, as you rightly put it, in Article 10, we have the values and we have the principles. And then there is a whole chapter on ethics among leaders, that you shouldn't even put your interest above the interest of the nation. All those, it's because the office, when you occupy an office in our trust, then you must be a symbol of national unity. The way you conduct yourself must be in a way that even the least of communities
they feels
that Kenya is home. Now, if we must impeach you for making us not feel like we belong, if that is a very great, in fact, in my opinion, the gravest sin that the deputy president has committed is his utterances. You know, his utterances
you don't believe
alone,
the kind of defense he gave?
No, let me tell you. And that is why, you see, among those charges that were upheld by the Senate, in my opinion, from where I come from, they are the most dangerous ones. I wish they upheld the charges on crime, because everybody would have laughed at them. Because how do you prove that Gachagua has stolen all that money you said he stole? You're not ESCC, you don't have that investigative power and such like things. But now on the utterances, when you stand and castigate the judge in broad daylight and you tell them mtaniona, when you tell people mkitisha nitakuwa natoka kitabu naangalia kama share zenyu ziko namna gani, you're very divisive as a character. And an argument might be brought forward, which makes a lot of sense, that he's not the only sinner, that many of those things he said, even his boss said it, but then, which true as it might be, the only answer to them is, the only person on the chopping board is the deputy president. Okay. And you cannot be forgiven because you said it as a multitude, because nobody else is on the chopping board. So those might whim the emotions of the people. In the court of public opinion, you win. That you are not, in fact, the deputy president is not the most sinful politician we have in this country. If others were to be brought against the same threshold, we could be shocked at their level of sinfulness. But then he is the one who is on the chopping board. Okay. And he cannot argue that I'm lesser compared. Face your ghosts alone. Okay, that was, I think, one of the defenses that were being given, especially in the National Assembly and also in the Senate, in terms of trying to compare. What I'm doing is, you know, what has been done before. And the argument was actually, we are not prosecuting President William Ruto. There is no motion on impeachment of the president. So we are actually focusing on the deputy president regarding Gachagua. That was. But I want to ask you this before we get to hear what is happening in the corridors of justice. You see, if at all this particular ruling says, okay, we vacate those conservatory orders staying the impeachment of our deputy president designate, or rather the swearing in of Kithure Kindiki, and we can go ahead and swear him in. Then we start now hearing the case on whether the process that was followed by the National Assembly or the Senate was in accordance with the Constitution. We would have sworn in the deputy president designate, right? When the corridors of justice later on find that what happened at the Senate was an injustice to the impeached deputy president. In that particular case, what would happen then?
Okay, now they actually tried to offset that situation in court, and it turns out there was a governor for Wajir who had been impeached, and his deputy took over as the governor. But that governor who had been impeached went to court and got orders. But by the time he got orders, the other one was already in office, and they had to get an order for the sitting governor to cede the office and resume his role as deputy governor so that the governor can take up the court.
Isn't that a faulty order?
It is not a faulty order, because what that was meant to say was that the argument here being that you might occasion an irreparable harm that cannot be compensated on the person who's asking for these conservatory orders. But at this particular position in Wajir, the damage had already been done by the time of going to court. And what the court did by reinstating the governor, they just provided that precedence for that specific position, that you can be removed from office and return when you're finished with your case. It offers no harm, because it is you. The only thing you lacked doing was not that there were so many things that you did not achieve, that you could not achieve in those days. It is only that you are not on your salary and maybe your benefits. Okay. But we can reinstate you back to your office. So that is the first legal juggernaut that the court has to deal with, because that's the balance that it is on. The argument on Gachagua's side is that you cannot you cannot accept this while you will go there and say I was unfairly treated and I was not impeached in the right process. I should be taken back. So what will happen to this person who has already been sworn in? So that was the legal situation that was brought about by that Wajir case. But on looking at it on Gachagua's side, you can clearly tell that he has an issue not only with his impeachment, but in the manner of his replacement and the person who is going to replace him, on the qualification of the person who is going to replace him. So that opens up another whole window of whether you would want to give a person an office and then have to redo all that because him being in that office has legal challenges. Remember, there's not just this case that is in court. There are Kenyans who have gone to court to challenge that gazette order that nominated Kindiki, quoting that we do not have a substantive IEBC in place, so you could not have gotten the approval for that IEBC. Then there's the argument that Gachagua brings forward that he was not a member of any political party by virtue of being in a state office. And so that balance, I would not want to put it to court and say, I will get the bashing if I am the one to stand on national TV and say the court should do this or the court should do this. But that is the situation that is there for Kenyans right now.
If I may ask, I am asking so that Wakili can help on one. For instance, assuming now the deputy president, former, is reinstated, or the courts hold that he was gotten out of the office unprocedurally, and we have a fully sworn in deputy president, can we now vacate the deputy president and tell him you don't hold this office rightly? There was one who held it before you, and now Rigathi becomes the deputy president. Is it even possible?
You're saying that, you know, at this point, the court is not making a decision on whether the impeachment was lawful or not. At this point that we are still on the preliminary stages, and we are arguing whether we should continue having conservatory orders and stay pending as we listen to Gachagua's case, and the court makes a determination on whether the impeachment was lawful or not. So the balance that I was trying to show was that on one side, from the government side, they would want the conservatory orders to be lifted, and they go on and swear in
their favorite candidate.
And the argument is that if at all this case gets to the conclusion and you find that Rigiji should be in office, there is precedence of court cases where people have gone to be reinstated to their office after it has been assumed by another person. And then from Gachagua's side, he argues that the qualification and the appointment process of his replacement is already at fault. So he would not go, because if Kindiki's nomination has been impugned in court, his qualification to be eligible for nomination, that is belonging to a political party and all that, has also been questioned. Then it would put the court in a bad position of having to not only say that Gachagua was unlawfully impeached, but also say that Kindiki was unlawfully sworn in.
So sworn in.
Yes.
Okay, then I think if at all, and we are looking at a possibility of going ahead, the court saying, of course, we lift these conservatory orders and we can go ahead and swear in the deputy president designate from East. What kind of political problem, now from the legal front, what kind of political problem does that present?
Firstly, it's a very tricky situation on quite a number of fronts. One is that the people of Mount Kenya West, majority of them feel that the seat belonged to them and it should have been brought back to West, and as a result of which, they would feel like, in as much as it is still within the mountain, it is not with them, and they have the bulky of number of votes. It would then mean that whoever has been replaced the former deputy would have to do a lot of covering of the ground to convince the people, because at the end of the day, what people ask is that, don't oppress us, give us an opportunity to thrive. If the deputy president would convince the people from West, in as much as I'm your cousin from the East, I'm equally qualified to champion for your plight and make sure that you've gotten what you deserve in this government, ensure that your cost of the products you produce get the best of prices, the roads that were being done or were supposed to be done get done, and that you don't get prejudiced in any way now that you've lost that seat to the East, then the people might still feel that we didn't lose much. Would there be seen by the people that is incapable of doing it? I can tell you the revolt from Mount Kenya West would be of untold proportions.
Okay. Why would you say that?
Because the people of Mount Kenya West, as you know them, you see, even in all these persecutions of the deputy president, nobody has come out, burn tires in town, or even to say mtoto wetu.
They say the deputy president did say that is impeached regarding Gachagua.
Don't touch Murima.
Yes,
no, not really, but there was expectation that we will take to the street. No, but that is they don't know us. And
our people don't do that. I can tell you, because I come from there. We wouldn't go to the streets. The only streets we'll go to is on the 9th. Is it 10th of August 2027? When we wake up and in one voice we express our displeasure with whoever took actions against us. Okay. That is how the mountain works. You remember, when the mountain felt that the President Uhuru treated Ruto in an unfair way, they didn't express it to him. The politicians did, but the people are silent. The president felt that he could still get the people behind him until when they woke up on 8th of August 2022 and they expressed their displeasure with the president. The President Ruto has to make sure that he does not suffer the same fate with the people. That they wake up on 10th of August 2027 and express the same displeasure with him to nearly to the last man.
How does he ensure that, though?
The only way to ensure that, firstly, is that he went to the people of the mountain and they gave him the votes. He has taken away a seat belonging to the West, he's given it to the East, but still within the region. It is now upon him to go and tell his people from the mountain that we are still together. What I heard wasn't an issue with the community, it was an issue with the person you gave to deputize me.
But I think he has already done that. By choosing Kindiki, he is already saying, I'm not against you. The seat is still within your region.
He has
and because the cousin you have said from the East, they have really supported the cousin from the West all the time. Why don't the cousin from the West now support the Easterners?
No, that is why I'm saying it is upon you convincing. You raise a very important issue that the work of the East can't be only to bring the numbers to make the West the bigger stakeholders in the government.
From the East.
You are the cousin from the East. Agreeable completely. Yes. But then, when you take something from the elder brother and you give it from the smaller brother, you leave it upon the smaller brother to do the work of explaining to the elder brother, why it isn't you who should get it all the time. So the question is Kindiki capable of coming to Kiambu, for instance, and telling the people of Kiambu, hey, gentlemen, I'm your son in as much as I can't hear what you say. that I'll champion for your rights as much as Gachagua would have done.
Let me ask you this, Kimani, because you see, when the talks of impeachment started, taking center stage in the country. Yes. It started as a rumor, and we saw leaders from the East coming out and say, okay, you see, we from the East are fronting Kithure Kindiki as the person that is going to be championing for our interests as this particular region.
In fact, even from the West came.
It was collective.
It was a combined.
As a people of this region, yes, we are going to front Kithure Kindiki to be
Yes.
able to now champion for our interest. Rigathi Gachagua has been very vocal about his love for the mountain and fighting for the people of the mountain. When we have leaders that come out and say, now we are fronting so and so to be now the person that, you know, speaks for this particular region, and yet we are claiming the presidency or the seat of the deputy president should be national and not, you know, be owned by a region, quote unquote. Yet you have leaders that want to personalize that and say, now our interests will be, you know, championed for this, and yet we have devolution.
One thing
so
we
where
must
do we draw
agree.
the line on that?
One thing we must agree is that we are both national and regional as a country, because we come from regions. He comes from Mount Kenya East. I come from Kikuyus of diaspora, by the way. Let me be You are from Western or Nyanza?
Western.
You see now, we all come from regions.
Yeah.
Now, when we conduct our politics, we share seats regionally. It is a reality we must come to terms with. If you touch Mudavadi, the people of Western will say, you're touching our son.
I'll have to cut you short.
Okay.
I think what you're seeing right now is, of course, the three-judge bench has already made its way into the Milimani Law Courts for this particular judgment. I want us to cross over to the Milimani Law Courts and get to hear what is actually happening on that particular front. Let us cross over to
Dr. Frida Mugambi on ruling on petition E565 of 2024, Rigathi Gachagua and 40 others versus the Speaker of the National Assembly, together with petition E522 of 2024.
May it please your lordship. My name is Degwanjiro. I have instructions to hold brief for Senior Counsel Paul Moite, Faith Waigua, Elisha Ongoya.
Hello, I believe that quorum has already been
It
taken.
has been. All right. Awesome.
This is the ruling. The structure of the ruling is that we have given the introduction, we have given the background, and we have given the analysis and determination. For the purposes of this ruling, we'll start from analysis and determination. Having carefully considered the applications, the responses and submissions and discussions referred to, we hereby distill the following issues for determination. 1, whether this court has jurisdiction over the consolidated petitions. 2, if one above is answered in the affirmative, whether the matters raised in the constitutional consolidated petitions are justiciable. 3, if 2 above is also answered in the affirmative, whether the conservatory orders in place can be lifted. In dealing with the above issues, we remain mindful that we are primarily engaged in a constitutional interpretation process, and that we must stay true to the established principles of interpretation. We have thoroughly examined and rendered ourselves on the appropriate approach to constitutional interpretation in ruling number 1, issued on petition number E522 of 2024, as consolidated with cohort number 1 petitions and hearing after referred to as ruling number 1. We therefore adopt that analysis as part of this ruling by way of reference, as we see no need to rehash the discussion therein. We will now deal with the issues for determination in seriatim.
And I will deal with the first issue, that is whether this court has jurisdiction over the consolidated petitions. The first preliminary issue that was raised before us is the jurisdiction of this bench. While it was also argued that the court has already determined this matter, rendering it res judicata, we believe it is necessary to revisit the issue due to the new arguments that have emerged during submissions and in light of the unprecedented nature of the case before us. We find it prudent to further clarify our jurisdiction so as to ensure that the issue receives the comprehensive and careful consideration that it deserves. In determining this preliminary issue, we are reminded of the authoritative words of Nyarangi J.A. in the widely celebrated case of owners of the motor vessel Lillian S. versus Caltex Oil Kenya Limited, reminding us that without jurisdiction, a court has no power and must down its tools in respect of the matter in question. This principle has since been reaffirmed in numerous landmark decisions by the Supreme Court, underscoring its centrality to the exercise of judicial authority. In the case of Machari and another versus Kenya Commercial Bank Limited, the Supreme Court was unequivocal in its holding that a court's jurisdiction flows from either the Constitution or legislation or both. Thus, a court of law can only exercise jurisdiction as conferred by the Constitution or other written law. It is quite a lengthy paragraph there. However, let me also say the Supreme Court stated that where the Constitution exhaustively provides for the jurisdiction of a court of law, the court must operate within the constitutional limits. It cannot expand its jurisdiction through judicial craft or innovation. And the quotation goes on. Likewise, in Adenga and two others versus Kibos Distillers Limited and 5 others, the Supreme Court again emphasized as follows: a court, even this court, that is the Supreme Court, cannot arrogate itself jurisdiction through crafts of interpretation, and a court ought to exercise its powers strictly within jurisdictional limits. End of quote. We find it necessary to address the issue of jurisdiction by examining the historical context of Kenya's constitutional drafting process, as highlighted by learned counsel Dr. Thiankolu in his submissions. Counsel presented the court with excerpts from earlier drafts of the Constitution, tracing the evolution that led to the promulgation of the 2010 Constitution. Notably, in all these earlier drafts, express jurisdiction was conferred on the Supreme Court to hear and determine disputes arising from the impeachment process. However, in the final promulgated 2010 Constitution, this specific provision was deliberately omitted. Based on this historical backdrop, counsel submits that even if this court were to find that this dispute is justiciable, a matter which we will address in the second preliminary issue, jurisdiction should lie with the Supreme Court and not with this court. We have carefully considered this argument, which the petitioners opposed. Article 2(1) of the Constitution is unequivocal that no person or state organ is above the Constitution. It further affirms that all state authority must be exercised in strict conformity with constitutional provisions. By virtue of Article 2(4), any act or omission that violates the Constitution is both unlawful and invalid. This establishes a clear basis on which the actions and omissions of all state organs must be scrutinized for their constitutionality. The bone of contention before us is whether that jurisdiction ought to be exercised by this court or by the Supreme Court. As we have already noted, the final version of the 2010 Constitution marks a clear departure from previous constitutional texts regarding the jurisdiction of the Supreme Court. Specifically, the provision granting the Supreme Court exclusive and original jurisdiction over disputes arising from the impeachment of the President, that bit was deliberately omitted. The Supreme Court's jurisdiction is now strictly redefined under Article 163, Sub-Article 3. This leads us to the firm conclusion that the people of Kenya did not intend to grant such jurisdiction to the Supreme Court. Had that been the intention, the Constitution would have expressly conferred this authority in its final form. The Supreme Court has itself acknowledged that its original jurisdiction as outlined in the Constitution is exhaustive. This implies that any attempt to expand its jurisdiction beyond what is expressly provided for would contradict the Constitution's intent. Again, we refer to the case of Machari and another versus Kenya Commercial Bank, in which the Supreme Court itself stated as such. Article 163 of the Constitution provides for the jurisdiction of the Supreme Court in exhaustive terms, though leaving room for Parliament to prescribe further appellate jurisdiction in terms of Article 163 3b2, which stipulates that the Supreme Court shall have appellate jurisdiction to hear and determine appeals from any other court or tribunal as prescribed by national legislation. The Supreme Court goes on to note that the Constitution also confers jurisdiction upon the Supreme Court to hear and determine an appeal from a judge who has been recommended for removal under Article 168(8). As far as we are aware, Parliament has yet to confer any further appellate jurisdiction upon the Supreme Court in terms of Article 163 3b Roman 2 above. Even with regard to the special jurisdiction previously conferred by Section 14 of the Supreme Court Act, which was repealed by Section 15 of Act number 26 of 2022, the Supreme Court was unequivocal in again affirming that this provision did not grant Parliament the authority to expand the court's jurisdiction beyond what is contemplated in the Constitution. The court expressed this position. Again, we go back to the case of Machari and another versus Kenya Commercial Bank and two others. It's important to read the text. The Supreme Court states as follows: what is the proper province of Article 163(9) of the Constitution? Does the article contemplate a situation where Parliament can confer further jurisdiction upon the Supreme Court? We hold that it doesn't. The act contemplated by Article 163(9) is operational in nature. Such an act was intended to augment the rules made by the Supreme Court for the purpose of regulating the exercise of its jurisdiction. It is an act that must confine itself to the administrative aspects of the court. It is a law that addresses the manner in which the Supreme Court exercises its jurisdiction as conferred by the Constitution or any other legislation. And they go on to summarize, such an act was never intended to create and confer jurisdiction upon the Supreme Court beyond the limits set by the Constitution. From this analysis, we have come to the conclusion that the jurisdiction to hear disputes arising from impeachment of the President and Deputy President does not lie with the Supreme Court within the realm of original and exclusive jurisdiction. Instead, such jurisdiction may be exercisable within the Supreme Court's appellate jurisdiction. We now turn to the jurisdiction conferred on the High Court under Article 165(3) of the Constitution. Notably, the High Court is also vested with a broad scope of original and somewhat residual jurisdiction under Article 165(5), which grants this court jurisdiction over all matters except those explicitly reserved for the Supreme Court or for courts of equal status. This broad jurisdiction demonstrates a deliberate intention by the drafters of the 2010 Constitution to empower the High Court to address matters not expressly covered in the Constitution, ensuring that no legal issues, including, as what is before us, impeachment proceedings, fall outside the court's purview. By vesting the High Court with such extensive authority, the Constitution also guarantees that gaps in constitutional coverage are filled, allowing the court to adjudicate on significant issues that may arise within the evolving landscape of governance. Within this framework, the jurisdiction conferred under Article 165(3) extends to adjudicating any alleged infringement of the Bill of Rights and interpreting the Constitution. In this context, Article 165(3)(d) Roman 2 expressly grants the High Court the authority to determine whether any act purporting to have been done under the authority of the Constitution or any law is inconsistent with or in contravention of the Constitution. This reinforces the High Court's pivotal role as the guardian of constitutional integrity, ensuring that all actions by state organs or individuals are in full compliance with constitutional dictates. A closer examination of the Constitution confirms that the drafters expressly intended to exclude the High Court from hearing appeals related to tribunals established under Article 144. Given this explicit exclusion, and against the foregoing discussion, if the drafters had similarly intended to bar the High Court from determining disputes under Article 145, they would have done so with equal clarity. Nothing would have been simpler, in our view, than to expressly exclude such jurisdiction in the same manner. The absence of such an exclusion with respect to Article 145 strongly suggests to us that the drafters intended for the High Court to retain jurisdiction over such impeachment matters. This approach to interpretation, whereby jurisdiction is said to be unlimited in the absence of any explicit limitation, is supported by the Supreme Court in their decision in the case of R versus Karisa Chengo. The Supreme Court noted as follows, we quote, "The limits of this authority are imposed by the statutes, charter, or commission under which the court is constituted and may be extended or restricted by like means. We emphasize that if no restriction or limit is imposed, the jurisdiction is said to be unlimited." The quotation goes further, but that is the emphasis statement. It is undisputed that the impeachment of the Deputy President is a constitutional process outlined in Article 145 of the Constitution. The authority to determine whether the merits and procedures of such an impeachment process align with constitutional requirements therefore falls squarely within the jurisdiction of the High Court as provided for under Article 165(3)(2). The role of the courts in an impeachment process was reiterated by the Supreme Court in the case of Sonko versus Clark County Assembly of Nairobi. That is another quotation that we have reproduced in our ruling when you get to read it. The court went on to state that the impeachment architecture in the Constitution, the law, and the standing orders leaves no doubt that removal of a governor relates to accountability, political governance, and personal responsibility, and not necessarily about criminal responsibility. It follows that insofar as the process of removal of a governor from office is concerned, the court's role is confined to deciding whether the governor's constitutional rights and fundamental freedoms have been breached in the process and whether the procedures for removal from office have been followed without the court constituting itself into any of the two constitutional organs in whose hands the power to remove is vested. While we acknowledge that this referenced decision pertains to the impeachment of a governor, we maintain that the same constitutional principles apply to the impeachment of a deputy president. And accordingly, we do hereby find and hold that this court has the jurisdiction to sit and determine the matter that is before it.
The second issue is whether the matters raised in the consolidated petitions are justiciable. Ordinarily, an application for conservatory orders concerning the subject matter of a suit is relatively straightforward, as the law in this area is well established. However, the current applications before the court are far from routine. These applications are imbued with political maneuvering between the applicants and the respondents. In essence, power struggles involving other constitutional organs have been brought before this court for a legal solution. As a result, this court has become the stage upon which political excesses are to be examined and resolved. Inevitably, such cases evoke intense emotions. The impeachment case of the first petitioner currently before this court exemplifies the dilemma faced by the judiciary when handling cases that straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue, one that has significant implications for the doctrine of separation of powers among the three arms of government. Answering this issue requires a brief analysis of the doctrine of separation of powers in relation to the doctrine of justiciability. French political philosopher Montesquieu first formulated the doctrine of separation of powers through his seminal work, L'Esprit de Louis, in other words called the Spirit of Laws, which was published in 1748. Montesquieu argued that such separation limits the possibility of arbitrary excesses by the government, since the sanction of all three branches is required for the making, executing, and administering of laws. The Constitution of Kenya 2010 clearly delineates the three arms of government, each with its own distinct personnel and roles, as set out under Chapters 8, 9, and 10. Chapter 8 establishes the legislature and details its composition, functions, and powers as the law-making body of the government. Chapter 9 outlines the structure, the functions of the executive, whose primary role is implementing and enforcing laws and policies. Chapter 10 focuses on the judiciary. It defines the structure of the courts and lays out the judiciary's mandate as the arbiter of disputes and the guardian of the Constitution, tasked with interpreting and applying the law impartially. While the provisions regarding judicial power under Chapter 10 of the Constitution are clearly defined, the political question doctrine, also referred to as the non-justiciability doctrine, highlights the limitations on the judiciary's role in adjudicating matters that fall within the purview of other branches of government. This doctrine essentially asserts that certain issues are not suitable for judicial determination because they are better addressed by the legislative or executive branches, which have the constitutional mandate and expertise to handle them. Black's Law Dictionary, 10th edition, at page 943 to page 944, defines justiciability as a matter that is, in quote, proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision. Close quote. There is an abundance of judicial pronouncements expounding on the doctrine of the political question. For instance, in Marbury versus Madison, Chief Justice John Marshall established the principle that while the courts have the authority to interpret the law, certain political questions are outside the scope of judicial review. The case underscored that where the Constitution assigns duties to other branches of government and does not provide standards for the judiciary to assess those duties, the matter is deemed as non-justiciable. Closer home, in William Odhiambo Ramogi and two others, versus Attorney General, a 5-judge bench observed as follows. The justiciability doctrine is rooted in both constitutional and prudential considerations and evinces respect for the separation of powers, including a properly limited role of the courts in a democratic society. One justiciability concept is the political question doctrine, according to which courts should not adjudicate certain controversies because their resolution is more proper within the political branches. In Baker versus Carr, the United States Supreme Court outlined 6 matters that could present political questions as follows. 1, a textually demonstrable constitutional commitment of the issue to a coordinate political department. Or 2, a lack of judicially discoverable and manageable standards for resolving it. And 3, the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion. 4, the impossibility of a court's understanding undertaking independent resolution without expressing lack of the respect due to coordinate branches of government. And finally, an unusual need for questioning adherence to a political decision already made and the potentially of embarrassment from multifarious pronouncements by various departments on one issue. Additionally, the Court of Appeal in Kenya Airports Authority versus Mitubel had this to say: with this in mind, the role of the legislature is to make laws and policy, and that of the executive is to implement those laws and policies. The role of the judiciary is to interpret the policies and laws as enacted and approved by the legislature and the executive. Generally, courts have no role to play in policy formulations. Formulation of government policy is a function best suited for the executive and legislature, close quote. In Kiriro versus Ngugi, a 3-judge bench had this to say: a court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of 3 doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. The doctrines are cross-cutting and closely intertwined. We shall, however, endeavor to, as far as possible, delimit the operation of each doctrine in isolation. Close quote. This bench is tasked with determining whether the issue of the impeachment of the deputy president falls within the category of cases where the concept of non-justiciability would prevent this court from hearing and deciding the matter. The essence of this question lies in assessing whether the political question doctrine would apply, thereby barring the court from intervening in what might be considered a matter reserved for legislative or executive branches under the Constitution. Learned counsel Dr. Thiankolu relied on the U.S. decision in Nixon versus United States to argue the case that the dispute before the court is a political question and hence non-justiciable. We have given due consideration to this decision, noting that it pertained to a dispute involving the impeachment of a Chief Justice of a federal district court in the United States. In resolving the matter, the district court held that it lacked jurisdiction to hear an appeal from the Senate regarding the impeachment of the chief judge, deeming the claim non-justiciable. In determining whether a dispute is non-justiciable, the court held that the test depends on whether, in quote, there is a textually demonstrable constitutional commitment of the issue to a coordinate political department or a lack of judicially discoverable and manageable standards for resolving it. The question to ask, in simple terms, is whether the 2010 Constitution specifically assigns the sole responsibility for resolving disputes arising from the impeachment of the Deputy President, as in our case, to another branch of government. Additionally, are there clear legal rules or standards that a court can apply to reach a fair and just decision on such matters? Within the context of the American system, and as articulated by the court, the learned judges answered the first question in the affirmative. They held that Article 1, Section 3, Clause 6 of the U.S. Constitution demonstrates a clear textual commitment of the impeachment process to the Senate. For clarity, this clause, known as the Impeachment Trial Clause, states, in quote, the Senate shall have the sole power to try all impeachments, close quote. We previously referenced the pre-2010 Constitution drafts that were brought to our attention by Dr. Tiankolu. What is evident from this text is that the people of Kenya clearly intended for the impeachment process to be a justiciable matter. This conclusion is supported by the fact that each constitutional draft contained provisions affirming this intent. This position is unsurprising when considering the historical context in which the Constitution was created. The people of Kenya sought to move beyond a past where the judiciary was often marginalized or bypassed in efforts to check governmental excesses. Instead, they envisioned a new constitutional order in which all branches of government would be held accountable and subject to comprehensive constitutional oversight. This aspiration was central to establishing a balanced system that ensured no arm of government operated beyond scrutiny. We are therefore not convinced, against a holistic reading of our Constitution, that there was any intention to deliberately place the impeachment power on the legislature with no judicial involvement. To hold otherwise would be to create an absurdity whereby the dictates of the Constitution under Articles 23, 160, and 165, 3D2 would be defeated. In our view, this decision is further distinguishable by the fact that the appointment of judges in the United States and Kenya differs significantly due to unique political structures and systems of government. Judicial appointments in the US are more overtly political, with the President and Senate playing direct roles. In contrast, Kenya's system emphasizes judicial oversight through the Judicial Service Commission, which is designed to limit political influence and promote greater judicial independence. Going back to the question that we posed previously, it is clear that unlike the US position, there is no textually demonstrable constitutional commitment of the issue of impeachment solely to any political department or institution. Drawing analogies, the fact that the American context states that the Senate sits to solely try impeachment disputes is a major departure from the 2010 Constitution. Even though the requirements for the two-thirds vote and the taking of an oath are identical, the procedure and provisions of the Constitution, as we have spelled out, leave no doubt that the Senate is not the sole determinant of the dispute. We have already expressed ourselves succinctly on the jurisdiction that has been conferred to this court under the Constitution in our previous decisions. It is now well settled that there are instances in which the courts will and should interfere with political processes. A few decisions suffice to demonstrate this position. The Court of Appeal in Martin Nyaga Wambora and 3 others stated as follows at paragraph 62, the political question doctrine and the concept of separation of powers cannot oust the jurisdiction of courts to interpret the Constitution or to determine the question if anything said to be done under the authority of the Constitution or law is consistent with or in contravention of the Constitution as per Article 165, sub-Article 3D2. Equally, as we have seen in the case of William Odhiambo Ramogi, the court stated that there are constitutionally permissible situations where this court may interfere in the policy decisions of the government, and particularly if a policy decision is in equal or in actual or threatened violation of the fundamental rights guaranteed under the Constitution or in violation of other provisions of the Constitution. The necessity of vindicating constitutionally secured personal liberties and fundamental freedoms is the principal justification for the anti-majoritarian power that judicial review confers upon the courts, and we are therefore reluctant to find that a claim of fundamental rights, such as the one presented by the petitioner, is non-justiciable, even though it may concern the political process or the internal workings of other government branches. Close quote. The crust of the petitioner's case centers on key questions, including whether the process was followed by the National Assembly and the Senate in the impeachment of the first petitioner, and whether the first petitioner was afforded sufficient time to prepare his defense against the impeachment charges. These issues strike at the heart of constitutional and procedural fairness, raising concerns about the extent to which legislative bodies adhered to the standards of due process as outlined in the Constitution. The petitioners contend that the impeachment process must align with the constitutional principles of fairness and justice, ensuring that any office holder facing such proceedings is provided with a reasonable opportunity to respond and defend against the charges. This court is therefore called upon to examine whether the procedural safeguards required by the Constitution were observed during the impeachment process, and whether any potential lapses could render the process flawed or unconstitutional. Such an inquiry would involve a careful review of the actions taken by the National Assembly and the Senate to determine if the principles of due process and fair administrative action were upheld. We take the view that, based on a holistic reading of the 2010 Constitution, the political question doctrine cannot oust this court's jurisdiction as granted under Article 165, sub-Article 3. Article 165, sub-Article 3 confers upon the High Court the authority to hear and determine questions regarding the interpretation of the Constitution and the legality of any acts or omissions by state organs. This provision underscores the High Court's critical role in ensuring constitutional compliance, even in politically charged matters. The Supreme Court of Kenya in Sonko case supports this position in its holding that impeachment proceedings are inherently political. They do not fall beyond the scope of judicial review. The court stated as follows, it's a fairly long quote, I've given it. In Martin Nyaga Wambora versus Speaker of the Senate, the Court of Appeal also held that judicial intervention in impeachment must be exercised cautiously. While conservatory orders may be issued to protect constitutional rights, they should not encroach upon the legislative process unless clear evidence of constitutional or procedural violations exists. The court underscored that judicial intervention should respect the separation of powers, ensuring that the judiciary does not undermine the functions of elected bodies. South African courts have similarly addressed the scope of judicial intervention in impeachment process, emphasizing the balance between constitutional oversight and respect for the separation of powers. A notable example is Economic Freedom Fighters versus Speaker of the National Assembly and others. This is a 2018 matter, which involved impeachment proceedings against former President Jacob Zuma. In this case, the Constitutional Court affirmed that while the judiciary has the authority to ensure that impeachment proceedings comply with constitutional requirements, it must exercise restraint to avoid encroaching on the disciplinary functions of the legislature. The court made it clear that judicial intervention is warranted only when necessary to correct political procedural irregularities or constitutional violations. The ruling highlighted that conservatory orders should be applied with caution to prevent unwarranted intrusion into the legislature's domain. The court had this to say, quote, "Courts must be careful not to impose themselves in a matter that disrupts the legislative process or undermines the authority of Parliament. Judicial oversight is essential to safeguard constitutional rights and ensure procedural fairness, but it should not extend to directing how the legislature carries out its internal disciplinary proceedings unless there is clear evidence of procedural defects or breaches of the Constitution." This decision underlines the principle that the judiciary's role in impeachment matters is not to take over legislative functions, but to ensure that such processes are conducted in a manner that respects constitutional norms and procedural fairness. It reinforces the idea that while the doctrine of separation of powers is crucial, it does not preclude judicial oversight when fundamental constitutional principles are at risk. It is therefore our finding, based on the above, that the Constitution of Kenya has clearly delineated independent and distinct paths for the three arms of government. Accordingly, this court's intervention in the matter before it is warranted through a very narrow window that allows for oversight in cases where constitutional infractions are alleged in the impeachment process. This position is reinforced by our previous determination that the petitioners have established a prima facie case in the petitions before this court.
And I will handle the third issue, that is whether the conservatory orders in place should be confirmed. We reiterate that we dealt at length with the nature and principles for consideration in applications seeking conservatory orders. That was in ruling number 1, which we delivered some few days ago. We adopt that discussion as part of this ruling by your reference, and suffice to say that the three main principles for consideration are as follows. The first one being that the need for the applicant to demonstrate an arguable prima facie case. The second, whether the public interest will be served or prejudiced by a decision to exercise discretion to grant or deny a conservatory order. And the third is that whether, if an interim conservatory order is not granted, the petition or its substratum will be rendered nugatory. We will consider the said principles as they play out in this matter. On whether prima facie case has been demonstrated, this is a discussion which featured in ruling number 1, where we dealt with the definition and the nature of a prima facie case. We held that such is a case which, and I quote, "On the material presented to court, a tribunal properly directing itself will conclude that there exists a right which has apparently been infringed by the opposite party as to call for an explanation or rebuttal from the other," end of quote. See the case of Mrao versus First American Bank of Kenya Limited and 2 others. In the said ruling number 1, we went further and said, I quote, "In sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law. In doing so, a court must be guided by Articles 22, Subarticle 1, and Article 258, Subarticle 1 of the Constitution, which provisions are on the right to institute court proceedings whenever a right or fundamental freedom in the Bill of Rights has been denied, violated, or infringed, or is threatened, or when the Constitution has been contravened or is threatened with contravention. End of quote. Upon being satisfied, this court, in the said ruling number 1, rendered itself as follows. I quote again. Applying the above in this matter, and without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration. End of quote. This court has not deviated from the above position. We reaffirm that the consolidated petitions in cohort number 1 and in cohort number 2 still raise constitutional issues requiring further judicial interrogation. The second issue is whether with public interest considerations. Black's Law Dictionary described public interest as the general welfare of a populace considered as warranting recognition and protection, something in which the public as a whole has stake, especially in something that justifies government regulation. In ruling number 1, we found and held that, quote, public interest tilts in favor of allowing the constitutional process to proceed unhindered, end of quote. To therefore understand how public interest factors into this matter, it is necessary to examine the historical context of the office of the now Deputy President. Naturally, the starting point is the retired 1963 Constitution, which hereinafter will be referring to as the 1963 Constitution. Chapter 2 of the 1963 Constitution addressed the executive, with part 1 thereof focusing on the President and the Vice President. Section 4 of the 1963 Constitution established the office of the President as follows, I quote, there shall be a President of Kenya who shall be the head of state and Commander-in-Chief of the Armed Forces of the Republic, end of quote. Section 6 addressed a vacancy in the office of the President. And I may not go through all that, but it's in the ruling, you'll find it. Section 15 of the 1963 Constitution dealt with the office of the Vice President. This one I will read. Section 15, subsection 1, read as follows, I quote, there shall be a Vice President of Kenya who shall be appointed by the President. Subsection 2, the President shall appoint the Vice President from among the ministers who are elected members of National Assembly, provided that no appointment to the office of Vice President shall be made at any time when the functions of the office of President are being exercised by any person other than the President. Subsection 3, the Vice President shall be the principal assistant of the President in the discharge of his functions. We have emphasized that provision. Subsection 4, the Vice President shall not enter upon the duties of his office unless he has taken and subscribed the oath of allegiance and such oath for the due execution of his office as may be prescribed by Parliament. 5, during his tenure of office, the Vice President shall not hold any office of profit other than those of Vice President, Minister, and the Member of National Assembly. Subsection 6, the office of the Vice President shall become vacant A, if the President so directs. B, if the holder of the office ceases to be an elected member of the National Assembly otherwise than by reason of the dissolution of Parliament, or C, upon the election of a person to the office of President. It follows that under the 1963 Constitution, the Vice President served solely as the principal assistant to the President in the discharge of the presidential functions. The vice president had no other duties and could be dismissed by the president at will. After a lengthy and others 20-year pursuit for constitutional reforms, Kenyans ultimately adopted a new constitution in August 2010, which we'll be referring to as 2010 constitution just to distinguish it with the 1960 constitution. The 2010 constitution has been widely praised as transformative, particularly for its fundamental restructuring of the country's constitutional and governance framework. The 2010 constitution establishes the executive in chapter number 9. Article 131 outlines the authority of the president, while Article 132 details the functions of the president. Article 147 provides for the functions of the deputy president as follows. The deputy president shall be the principal assistant of the president and shall deputize for the president in the execution of the president's functions. 2, the deputy president shall perform the functions conferred by this constitution. We emphasize that. The deputy president shall perform the functions conferred by this constitution and any other functions of the president as the president may assign. Subject to Article 134, which deals with temporary incumbency, when the president is absent or is temporarily incapacitated, and during any other period that the president decides, the deputy president shall act as the president. And sub-article 4 says that the deputy president shall not hold any other state or public office. It is therefore beyond any peradventure that the role of the president's principal assistant changed significantly in the 2010 constitution compared to the position of the vice president under the 1963 constitution. Some of the notable changes include: 1, whereas the vice president was solely the principal assistant of the president, the deputy president is both the principal assistant of the president and also deputizes the president in execution of the president's functions. 2, the deputy president performs specific functions conferred by the constitution. 3, the deputy president may perform any other functions of the president as the president may assign. 4, unlike the vice president who was appointed by the president from among cabinet ministers who were elected members of the National Assembly, the deputy president under the 2010 constitution is elected together with the president and holds no other public office. The above changes were not without reason. In the book, The Constitution of Kenya, commentary by Louis and PLO Lumumba, this is the second edition, Strathmore University Press, they are 2019 at page 453. The two eminent authors had this to say, and I quote: with the other arms of government considerably weakened, the executive personified in the president exercised unchecked powers. Indeed, during the constitutional review process, the CKRC noted that the powers granted by the constitution and the ordinary laws to the elected president seemed to share characteristics with those of the colonial governor. It then resolved during the constitutional making process to divest some powers from the president with the aim of avoiding an imperial president, end of quote. The above cannot be far from the truth. In the pre-2010 constitutional era, the president held immense powers, including the ability to appoint and dismiss the vice president at will and the discretion to assign or to withhold duties for the vice president. Consequently, the vice president served entirely at the president's mercy. That was the framework that the 2010 constitution sought to transform. Under the 2010 Constitution, the office of the Deputy President has been fundamentally redefined. It is now safeguarded from arbitrary and capricious actions by the President. Article 172 grants the Deputy President specific constitutional functions in addition to any duties the President may assign. This provision was intended to address the previous situation in which a President could, for any reason, choose not to assign any duties to the Deputy President, effectively sidelining them. Thanks to the 2010 Constitution, even if the President does not assign any additional duties, the Deputy President still has specific constitutionally mandated functions to perform. In this way, the Deputy President is no longer at the mercy and the discretion of the President. Under the current constitutional framework, when the office of the Deputy President becomes vacant, two outcomes flow. First, any functions that were assigned to the Deputy President by the President automatically revert to the President. Second, the functions expressly conferred upon the Deputy President by the Constitution do not revert to the President and cannot be performed by anyone else. This is a departure from the 1963 Constitution, under which the President could appoint a minister to act as Vice President in the Vice President's absence. The 2010 Constitution includes no such provision. Therefore, if the office of the Deputy President is vacant, the specific constitutional functions assigned to that office remain unfulfilled. For clarity, not even the Speaker of the National Assembly may discharge the functions vested in the Deputy President under Articles 147, Subarticle 2 of the Constitution. In light of the above, we are convinced and hereby find that the current constitutional framework does not envision any scenario in which the office of the Deputy President will remain vacant except during the brief period required to fill such a vacancy. Another equally important provision that adds credence to the above position, that the office of the Deputy President cannot be left vacant, is Article 146(3) of the 2010 Constitution. However, before we interrogate the said provision, suffice to note that Article 150, Subarticle 2 of the Constitution, which is on the removal of the Deputy President, has it that the provisions of Articles 144 and 145 relating to the removal of the President shall apply with the necessary modifications to the removal of the Deputy President. Returning back to Article 146, which article deals with the vacancy in the office of the President. Sub-articles 1, 2, and 3 of that article provides that follows. These ones I'll read. Sub-article 1, the office of President, read Deputy President, shall become vacant if the holder of the office A, dies, B, resigns, in writing addressed to the Speaker of the National Assembly, or otherwise ceases to hold office under Article 144, which deals with removal of President on grounds of incapacity, or Article 145, which deals with removal of President by impeachment, or under any other provision of the Constitution. Sub-article 2, when a vacancy occurs in the office of President or Deputy, 1, the Deputy President shall assume office as a President for the remainder of the term. 2, if the office of the Deputy President is vacant or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of President shall be held within 60 days after the vacancy arose in the office of President. Sub-article 3, a person who assumes the office of President under Clause 2A or following an election required by Clause 2B shall, unless otherwise removed from office under this Constitution, hold office until a newly elected President is sworn in following the next regularly scheduled election under Article 136, Sub-article 2A. End of Sub-article 3. Therefore, to us, a holistic reading of Article 146 alongside Article 152 of the 2010 Constitution, and in relation to the filling of a vacancy in the office of the Deputy President in this matter, yields the meaning that the person who assumes the office after the impeachment of the Deputy President shall, unless otherwise lawfully removed from this office, hold that office until further orders of this court or until the current term of the President ends, whichever comes first. The foregoing demonstrates that the structure of the Constitution, which reflects the popular will of Kenyan citizens, envisions a scenario in which the office of the Deputy President will always be filled except during the brief period of required to fill the vacancy as already stated above. Based on the foregoing, we now turn to the nature of the conservatory orders in this matter. It is widely accepted that the purpose of conservatory orders is to preserve the status quo pending further orders of this court. The Supreme Court in Gatirau Peter Munywa and Dixon Mwenda Githinji and two others said as much. In this case, maintaining the status quo would mean, one, that the first petitioner remains impeached under Article 145, sub-Article 7, which affirms the finality of the impeachment process with the following provision, I quote, "If at least 2/3 of all members of Senate vote to uphold an impeachment charge, the Deputy President shall cease to hold office," end of quote. Two, additionally, the prevailing status quo will mean that the Deputy President nominee, Professor Abraham Kithure Kindiki, does not assume office. With such an approach, while such an approach may seem fair, reasonable, and balanced, and one which this court would ordinarily be inclined to adopt, the unique nature of the Deputy President role under the 2010 Constitution suggests a different course. Allowing these orders to stand will leave the office of the Deputy President vacant. The problem, however, is that no other person is authorized to carry out the constitutional functions specifically assigned to the Deputy President under Article 147, sub-Article 2, once those assigned by the President revert to the President in the absence of an office holder. The result would be a de facto suspension of Article 147(2) of the Constitution, an outcome that no court should knowingly permit. For clarity, this court firmly holds that no court should issue orders that have the effect of suspending the operation of any provision of the Constitution, such an outcome is clearly not envisioned by the document itself. The Constitution was not handed to Kenyans on a silver platter. No, it was achieved through great struggle and sacrifice. Therefore, it is the duty of the court to uphold its provisions as intended by the framers and as demanded by the people of Kenya. Furthermore, Article 259 of the Constitution mandates that the document must be interpreted as always speaking. This means the Constitution is a living document designed to address contemporary challenges and to be applied consistently and continuously without interruption. Suspending any provision of the Constitution, even temporarily, would undermine this principle by creating gaps in its operation and disrupting the intended balance of governance. The Constitution is structured to ensure that all its provisions are effective and operative at all times. If any provision, such as Article 147, sub-Article 2, is rendered dormant by a judicial order, it risks setting a precedent where parts of the Constitution could be selectively switched off, effectively weakening the Constitution's authority and the protections it affords. Additionally, we are mindful that courts are guided by the principle of constitutional supremacy, which requires that all judicial decisions align with the Constitution's objective and upholds its integrity. Issuing an order that suspends a constitutional provision would directly contravene this principle, effectively placing judicial discretion above the supreme law of the land. This will be inconsistent with the spirit of judicial restraint and the court's role as a protector and not a modifier of the Constitution. For these reasons, we take the position that the Constitution must remain fully operational at all times, and no court order should have the effect of rendering any part of it inoperative or dormant. The court's responsibility is to interpret and apply the Constitution as a cohesive functional document that serves the people's enduring will and protects the structure of governance as established. Drawing from the above, we hereby find and hold that public interest in this matter favors giving way to the Constitution, which in any event is the will of the people. That is also the dictate under Article 3 of the Constitution, where every person has an obligation to respect, uphold, and defend the Constitution. We choose to abide by that calling. As such, public interest demands that the office of the Deputy President should not remain vacant. Whether the consolidated petitions will be rendered inhibitory in the absence of any orders. As we stated in ruling number 1, because the consolidated petitions challenge the entire impeachment process, the fundamental issues at stake remain live, even though the parliamentary proceedings have been completed. Furthermore, as previously noted, should any of these petitions succeed, this court will have no shortage of effective remedies to address the situation. The next issue is whether the applicants will be prejudiced if the orders are not granted. Regarding whether the applicants will suffer any harm if the conservatory orders are not granted, we find that no individual can suffer loss or damage when the Constitution is permitted to operate as intended. Allowing the constitutional process to unfold does not in itself result in detriment, as it upholds the rule of law and respects the framework agreed upon the people. The applicants also urge the court to grant the conservatory orders, expressing concern that the respondents have a history of disobeying court orders, and that once the office of the Deputy President is filled, it will be impossible to remove the appointee, even if the petitions were successful. However, this court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience of court orders. Moreover, the Honorable Attorney General, through Senior Learned Counsel Professor Getu Mugai, has given an undertaking to comply fully with any orders which will be issued by this court in this matter. As such, we find that the applicants do not stand to suffer any prejudice in the event the conservatory orders are not granted.
This position, as we conclude, we reiterate that this matter holds significant public interest, and we remain committed to an expeditious examination of the petitions. Therefore, we will further provide directions within this ruling. Consequently, the following orders are hereby issued. 1, the applications for conservatory orders are hereby disallowed. 2, the conservatory orders issued on 18th of October 2024 in Keregoya High Court E015/2024 are hereby discharged and or set aside. Costs of these applications shall be incurred. We grant leave for appeal, typed proceedings, and certified copies of this ruling to be availed to parties at cost or as it may be. We will mention this matter on 7th of November 2024 at 2 p.m. in the open court. This ruling shall forthwith be uploaded in the court tracking system. That is the ruling of the court.
Most obliged, my lord, and I have an
Much obliged, my lord. We want to take this opportunity to thank your lordships for the time that you have taken and the judiciousness with which you have expedited the applications. And I also want to thank my colleagues from the respondent side and from the applicant side for the maturity with which this matter has been handled. We are most grateful, my lord.
Thank you.
My lord, my name is Ochiel Dudley for the Deputy President, and I wish to make an application. The application I wish to make is called the Madhu Pepper Injunction. Madhu Pepper International, quite a famous case. In the common law, it's called the Erin-Ford injunction. My Lord, the Madhupepa injunction operates on quite a simple premise, the premise of human fallibility. In the case of Erin-Ford, where that injunction originates, Justice Megari, after dismissing an application for injunction like you have now, found still that there could be the slightest chance that he was wrong. Here, there could be the slightest chance that you're wrong. Last week, this court gave the Deputy President leave to appeal. We thank the court for that generosity. The Deputy President has appealed. He also has pending before the Court of Appeal an application for stay of these proceedings, and that application comes up on the 6th of November 2024. My Lord, operating on the premise of human fallibility, the foundation of the Erin-Ford or Madhupepa injunction, we request you to recognize that you could be wrong. And if you're wrong, then the pending proceedings before the Court of Appeal would be rendered nugatory. To avoid that possibility, the possibility that the Deputy President's right to appeal, which you recognized and affirmed and upheld by giving him leave to appeal, even where he needed none, we ask you to issue a Madhupepa injunction. We do not seek an indefinite injunction. We seek an injunction until 6th of November 2024, when we are next before the Court of Appeal. Thank you, my Lord.
My Lord,
we also have a moment to bite the cherry.
The Black Bull, okay.
Yeah. My Lords, I want to associate myself with the submissions made by my learned friend, and also state that I have listened keenly to the ruling that has been delivered by this Honorable Court. While we largely disagree with it and we have a right of appeal, Your Lordship, it is imperative for us to know or to assess how that office of the Deputy President will be filled. This court has affirmed its commitment to observe the rule of law and protect the Constitution as decreed under Article 3 of the Constitution. It follows, therefore, Your Lordship, my ladies, that the filling of that vacancy must flow or must follow the Constitution. And as such, Your Lordship, and as much as I have not heard the court address that very pertinent issue, it is my submission, Your Lordship, that I rise under Rule 23, beg your pardon, Rule 23 and Rule 24 of the Mutunga Rules. And I make an application, Your Lordship, that pending the determination of this application, done under Rule 24, that this Honorable Court does issue conservatory orders suspending the swearing in of Professor Kithure Kindiki on the following grounds. Your Lordship, Article 10 of this Constitution, of the Constitution, bids this Honorable Court to observe the rule of law. It further calls upon this Honorable Court to commit itself to ensure that there is good governance, there is accountability and transparency in the manner in which matters are done or functions are executed.
My Lord, with your kind permission,
it's an application.
Mr. Jero has referred to an application for which he's seeking some orders pending, but we haven't seen any application in that regard.
Yes, Your Lordship, if Mr. Kamotho was keen to read the rules, the Mutunga rules allows me to move you informally. And subsequent to me making an application informally, the court is called upon to reduce the same into a formal application. And that, Your Lordship, I want to draw his attention to Rule 24, Sub-Rule 1. An application under Rule 23 may be made by way of notice of motion or by an informal document. Your Lordship, permit me to proceed with the grounds of my application. It is clear, Lordship, that the court...
My Lord, if I may, I respect my learned friends. My Lord, I respect... Yes, I respect Mr. Njiru. He's referring to an application that is non-existent. Either he's referring to E554. Mr. Kamina, sit down. E554 of 2024, which is before the Court of Appeal, if you are referring to that application. But my Lord, if my learned friend is referring to the exercise of this court of epistolary jurisdiction, then he should say so. But he cannot refer to the exercise of that jurisdiction, my Lord, when this court is functus officio. You have rendered yourself on the question of the application. And therefore, they cannot urge an application unless they say, my Lord, number one, is either served on us, or two, my Lord, because there's already an application for stay under Section 5(2)(b) of the Appellate Jurisdictions Act before the Court of Appeal that is live and that has a date. This court would not have jurisdiction to entertain any other application for stay. They tried making an application before the Court of Appeal this morning using the same issues, my Lord, and the Court of Appeal rejected the application. They were told to serve everyone else. So, my Lord, for my learned friend to come here and to seek to apply for stay again, having a second bite at the cherry, is dishonest, my Lord. It's dishonest. They are before the Court of Appeal.
So, may I suggest, Professor Gender, that could be your response to the application which will be made by Ndegwa?
Yes, if there's an application, yes.
Thank you, Your Lordship. Your Lordship, permit me to move on with my application, and I urge Professor Ogenda to have a look at the rules that I have just referred to, that Your Lordship, you be kind enough to interrogate the circumstances under which that office shall be filled. Your Lordship, it is on record, and I invite the court to take judicial notice, that there is a clear non-existence of a crucial state organ that is supposed to oversee the processes of filling of that office in the name of the Independent Electoral and Boundary Commission. Your Lordship, the Independent and Boundary Commission is created under Article 88 of the Constitution, and the functions are created therein. One of the functions, my lords, my lady, is to maintain a voters register, is to register voters. Under Article 99, Your Lordship, of the Constitution, as read together with Article 137, creates the qualifications upon which the president or the deputy president must attain if one is to hold office. My ladies, my lord, it is clear that the functions created under Article 99 of the Constitution can only be executed and or implemented by the Independent Electoral and Boundary Commission. It goes without saying, my ladies, my lords, that a deputy president designate or nominated must attain those qualifications. That is to mean, my ladies, my lord, that there must be an organ that will give a clean bill of health to say or to suggest that Professor Kithure Kindiki attains these qualifications. My lords, my ladies, I refer to the memorandum that was sent to the Speaker of the National Assembly by the President of the Republic of Kenya, dated the 18th of October 2024. In that memorandum, your lordship, the President drew the attention of the Speaker to the clearance of the designated candidate by the IBC. And this is what the President had to say. Your lordship, the President indicated that he has had confirmation that Professor Kithure Kindiki meets and attains the qualifications created under Article 99 as read together with Article 113 of the Constitution. My ladies, my lords, when the President of the Republic referred to the IBC, and I call upon the court to take judicial notice of that document, it was a presumption that that confirmation was done by the Electoral and Boundary Commission as created by the Constitution. My ladies, my lords, it is my humble appeal that this honorable court does fight in my favor to issue the conservatory order on the basis that there is no clearance that has been issued by the IBC.
My lord,
we all know, my ladies, my lords.
My lord, may I kindly seek your guidance? When Mr. Giro started off, we thought it would be a simple and a straightforward application. But now, seeing the trajectory it has taken, he has raised an avalanche of issues for which we would require them reduced in a particular format so that we can seek instructions from our clients. So we'll be seeking that we get a formal thing that will enable us to seek instructions from our clients. Dr. Kamodo, for the 10th respondent.
Your Lordship, I am making an application on the basis of the law. Your Lordship, if it is not crucial for us to have an IBC to confirm whether Professor Kithure Kindiki is a registered voter, that would mean, Your Lordship, that a person can go to Mathare Hospital and designate a person to become a deputy president. The qualifications created by the Constitution have a mechanism of being established, Your Lordships. And the process of establishing those qualifications, Your Lordship, is set down and out in law. Your Lordship.
Mr. Njiro, my understanding, when,
yes, Your Lordship.
When you first asked for this conservatory order,
yes, Your Lordship.
under Madu paper,
yes, Lord.
That
is his application.
Yeah.
I have on a different application. I moved under Article 23.
Because my understanding is that if you want the court to give conservatory orders immediately after rendering a ruling or a judgment, that application can be verbal, but also very short, because the court is already aware, has already expressed itself.
That's correct.
So that kind of application cannot be the beginning of another big
Your Lordship, I am well guided.
So I think for the purposes of the discretion of the
yes,
bench,
Lordship.
For the purposes of the discretion of the bench,
yes, Lordship.
I think Mr. Ochieng's application is what we should be considered. Your application evidently requires to be formal.
Your Lordship, I am well guided by the court, but the court also needs to perhaps appreciate the import of Rule 24, that due to the vulnerability of the rights and the vulnerability of the infringement and the violation of the Constitution, I can appear before you.
Rights cannot be vulnerable. Individuals are.
May I have
not
my
rights.
time and then you have your response, Professor? Your Lordship, this application is premised again on Article 3. The call upon every person to protect the Constitution. And as I pen off, it is all clear to us that nobody can deny, not this court, not myself, Nobody can bury his head under the sand that there is no IBC. If Kithure Kindiki is to be sworn in tomorrow, what will be the import of swearing in a person who has not been verified and approved by the organ that is supposed to do so? Finally, Your Lordship, can this court fold its hands and watch and midwife and babysit a violation of the Constitution? What is the role of the court when it comes to the issue of Article 3 of the Constitution and the question of the sovereignty of the people? Your Lordship, I beg that you hear us. I beg that you grant the conservatory order staying the swearing in of Professor Kithure Kindiki on the basis that he has not qualified to hold that office. Secondly, on the basis that his purported qualification has not been verified by the body that is mandated to do so. In the absence of that, Your Lordship, you will be inviting us to say that even an insane person can become deputy president, a bankrupt person can become deputy president.
Objection.
I rest my case.
My Lord, let me respond to... can I respond?
Professor Ojenda and,
yes, my Lord,
and every other counsel who is seated, please sit down. We have two applications, and this is not going to be a start of another court process. It's not going to be a start of another court process. The applications which have been made are discretional. So I'll only allow one response, and then we'll render a ruling. Only one response.
Yeah, my Lord, if I may respond, my Lord.
My Lord, kindly, with your permission. With your permission.
My Lord, you've made a ruling.
Okay. Okay, let me hear two people from this side.
Okay, then two from... You're one person.
Dr. Kaminwa, please say what you want to say and be mindful of time, please.
I want to take my time. Justice Eric Ogola, Justice Anthony Murima, and Justice Frida Mugambi. I've listened to what you have said very carefully. And from my point of view, one who is interested in developing the students of the country, you have done so. You have developed this country. But there is one thing I would like to point out to you very respectfully. That you are operating in very dangerous waters with strong currents. And this is an area where we have to call for wisdom, we have to call for deeper understanding of human nature, and for deeper understanding of the society in which we live in Kenya. And what I'm saying to you is reflected in my broad pleading of the authorities in cases in the United States of America. Your Honor, if I may say so with respect, perhaps more than anybody else, when I was engaged to get involved in this case, I ordered for books from India straight about 11 volumes on impeachment. And I've taken the trouble to read them day and night. And one thing that has emerged from all these authorities when I was reading them very carefully is that the court in the United States have continued to think very carefully, how will this judgment be received by the people, by the consumers? How will it be received? Is it a judgment that will continue to promote stability in the country? Is it a judgment that will continue to promote the rule of law? Is it a judgment or ruling will continue to promote stability in the country. And it is here that I'm inviting you very respectfully that you consider the able remarks of my learned friend, Mr. Gachagua, that we should not, and my friend Mr. here, we should not ignore what they are saying like we are talking. With a tremendous respect, we don't want to move out of this courtroom and then all of a sudden we are told that they have put us down in my Lord, I'm not trying to keep saying with your
just hold on.
All that I'm saying to you,
Sorry, my lords. The utterances by the Honorable Dr. Hamino, Council, are. I'm giving you the titles.
No, what I'm saying, let me say what I'm saying.
Unfortunately, they're inciting, they're insightful, they are trying to preempt matters that are not before this court. We do not know and we cannot speculate that anyone is going to be happy or unhappy about it. The sword of justice cuts both ways. There are those who are going to be happy, there are those who are going to be unhappy. That is how life is, but you cannot incite by saying from here, we will have protests, we will have what? We do not know of that. Unfortunately, my lords, I ask you to kindly restrain him from taking that route.
With your kind permission, Your Honor.
Please sit down. Please sit down. We want you to know that we have rendered ourselves in this matter. We have rendered ourselves in this matter, and we are not going to open this matter for a further court proceeding. There are two applications before the court, one by Dedlo Chieng and one by Ndegwa. After Dr. Kamuna has spoken, we'll allow two people to respond, and then we'll make a ruling.
My Lord, I was to also, you indicated that two people, and I was prepared kindly to make an application.
Continue, Dr. Kamuna.
No, my Lord, I'm actually showing one sentence. When you read the rules, I have referred to the authorities in America. The judges have made a finding along this line. Yes, this is a bit of so and so is guilty, but we cannot go ahead. We shall be held. So that's all I'm saying to you. You have heard, you have come up with a very, if I may say so, a ruling full of jurisprudence, and particularly my man, the Lord Gachagua, has come up with something that I had not thought of very much at all. But all that I'm saying to you, that you agree, but you still have the discretion to say that, look, we are not, we have fixed our findings, but still we are going ahead to give conservative orders for so many days or so many weeks. So you still have that discretion for the sake of the country. Thank you.
My Lord, in brief response.
May I kindly, my name is Sam Nyaberi. I appear for the 9th petitioner in the 2nd cohort. My Lord, I stand to make an application for stay of the orders that have been issued this afternoon relating to the application that was before you, and having keenly listened and internalized the import of that ruling or order, my Lord, we wish to move the court, much as we have that opportunity by way of the orders that were given, that we were given a right to appeal, that pending the appeal, pending the lodging of the appeal, my Lord, my Lords and my Lady, you allow us that opportunity of stay so that we can ventilate our issues before the appellate court. My Lord, what informs this application is that there is an apparent risk by the fill-up of the position of the Deputy President, and in our petition, we had named the Professor Kithure Kindiki as a party in the petition that we had filed for the 9th petitioners. So that, my Lord, having analyzed and internalized that, we feel that the petition, in the fullness of time when the court is going to process it, we will be dealing with an issue that perhaps will compromise the rights of the ninth petitioner who has moved the court. And, my Lord, the other issue is that there is a period within which the respondents, if they have to move, they have to fill up that position of the deputy president. So that, my Lord, there is no any prejudice that will be occasioned to the second respondent if the orders of stay gets issued, because by close of business today, my Lord, we are going to lodge the notice, and that notice by itself acts as an appeal, and in the fullness of time, we shall be processing the application before the appellate court for appropriate orders to issue. My Lord, I therefore associate myself with my colleagues on the application for stay so that we don't have the proceedings before you in the fullness of time when we come to canvass the petition to be rendered nugatory or academic. My Lord, you have the discretion, and we ask and beseech you to exercise that discretion in the favor of the ninth petition. Thank you, my Lord.
My Lord, I would like to make an application under Article 1.1 directly. My lady. My lords and my lady, we are thankful for your ruling today and the lengthy explanations and case law that has gone into it. Unfortunately, my lords and my lady, it seems that some people are being favored over us, and in this matter, it is the state or advocates. We are here acting in person, and we are entitled to the same equal protection of the law. We are here trying to defend the Constitution and our constitutional rights. I am being discriminated against as a woman, as a person with disabilities, and as a youth, my lords and my lady. We filed our application on the 8th of October 2024, and we thought that we would be enjoined as interested parties to participate in Tuesday's proceedings, but we were not. So we did not have the time to ventilate our issues properly. My lords and my lady, we are asking you to stay your orders for 7 days, as you have told us to come back on the 7th of November, so at least we get a fair chance, a fair fighting chance as a sovereign to also ventilate our issues properly. The state cannot override us, and advocates cannot override us, my lords and my lady. This is a court for equality, and we are asking for equality. My lords and my lady, we also appreciate that regardless side has asked for 7 days to appeal. Kindly consider us in, because there is no point in justice. It will be granted to some petitioners, and others will just be thrown under the bus and into the darkness. Thank you.
My lord, if I may respond, my lord.
Sorry, just a minute. Can you just clarify your application? You say is dated the 8th of October?
8th of October, 2024.
Substance of the application?
It's petition E541 of 2024. We were seeking stay orders to stay the proceedings in the National Assembly based on Article 32(1), freedom of conscience, and Article 33, freedom of expression.
Fiona, maybe with your kind permission.
Let me clarify. Is that the matter in which you are appearing with Dr. Eboso?
Yes, my lord.
Yes. Now, if you have been following the directions of this court keenly, we have been issuing various orders on consolidation. And I can assure you, I did that. And you and Dr. Bosso are petitioners in one of the cohorts. I think it's cohort number 1. Yes, it's cohort number 1. You are petitioners in cohort number 1. And we directed everybody to get into the CTS system, and whoever has a problem to get in touch with the deputy registrar. So it is not right, Ms. Wanjiru, to claim that you have not been enjoined in these proceedings. You have been enjoined. You are a party, and that is why we allowed Dr. Bosso to address the court, even yourself to address. So you are a party. You are a party. That one I can assure you.
My lord, we were not entitled to the right of enjoinder and we had points that we wanted to defend against the respondent side. So we're just finding it very difficult that due process is not being followed in our instance, as we applied even before both parties on the 8th of October 2024. They came to court on the 18th, 10 days after us, and they have still been granted audience before us, and we were told we're going to be in cohort 1, and then cohort 1, this application has already overtaken cohort 1. We're now being told to come next week after the swearing in would have been gone through and after numerous rights would have been violated that we have raised.
I think, Ms. Wanjiru, what you just need to do is just get into the CTS, get all the directions. There's every direction. There's a reason why we came up with cohort 1 application petitions and cohort 2 applications.
Yes, my Lord.
So I think we may not wish to respond on whether you are discriminated or not, but we are so sure you are not discriminated because there are proper directions in respect of every cohort and every matter before us. Kindly take time to go through the CTS.
Yes. My Lord, thank you. This court had made directions on this issue. We said there are only 2 applications before this court right now, and those are 2 applications which will be responded to. We have applications. We are finished with this side.
You have not spoken on behalf of the second petitioner.
My Lord, that we would like an opportunity to respond to both applications that are being brought today.
Maybe I can say one thing, just on behalf of the second petitioner. My name is Kimotho Teresia Wanjiru Makazi. Yes, there's Kimotho in company Advocates Kegoya. I just wish to say we welcome the ruling. However, there are some bits that we feel aggrieved and we wish to appeal. And therefore, as we do the notice of appeal, we are praying that we are in support of the issue for injunction, no the issue for stay, which the court may say it's a negative order, but we are saying pending the time we do the appeal, at least the status quo be maintained. And also we wish to say that there was an issue that the Court of Appeal today, application for stay, that is not true. We were told to serve, parties were not all served, and that's the reason why we were given another date. So therefore we are in support of these 2 applications that have been made today.
Thank you. Let's Wanjiru also. Mr. Dr. Boso, please sit down. Please sit down.
My Lord, this court.
Please sit down. Please sit down.
Will I be given a chance to speak?
Please sit down. Ms. Wanjiru, proceed.
Yes, my Lord. As a young woman, I'm under 35, my Lord. I'm actually 35. I'm a youth and I have a disability. And we're the only ones, I think, on the platform that check that we have a disability, my lords and my lady. Our Constitution, Article 1.1, has to count for something, because it was intended for us to come to court directly.
Please respond to the application. Make the application.
Yes, my Lord, I'm in support of the application. Mr. Obliged.
My Lord, finally. My Lord, in response to the 2 applications, yours also an application. Yes, my Lord, in response to the application by my learned friend, Mr. Ochiel, future senior counsel, and my learned friend, Mr. Wanjiru, I wish to set as follows, my Lord. My Lord, number 1, the Matthew paper order sought by my learned friend fall on the basis of the following principles. Number 1, my Lord, there is already an appeal that has been filed in the Court of Appeal, and an application for stay under Rule 5 to be filed, being application number 554 of 2024. The Court of Appeal is therefore seized of this matter, already seized of this matter. In those circumstances, my Lord, a party can only apply for stay in the Court of Appeal. That's point number 1. My Lord, point number 2, ordinarily, when a court delivers a ruling in a matter, the court becomes functus officio in respect of that particular matter. My Lord, that matter therefore, or the applications made are therefore res judicata in the sense that a determination has been made, and this court cannot go back and approbate and reprobate at the same time. You cannot deny an order and then purport to issue the order again. Point number 3, my Lord. My Lord, rules 23 and 24 of the Mutunga rules as presented before you, together with an application by my learned friend on substantive issues touching on actions that may be undertaken subsequent to this, including, my Lord, the qualifications of the Deputy President nominee, Kithure Kindiki, can only be brought to this court, my Lord, through one, either a new petition and a new application, or two, my Lord, through an application for review. The only avenue that Mr. Ndegwa can bring all the issues that he has spoken to this afternoon are applications through review. No application for review or setting aside has been filed before this court by Mr. Ndegwa. And therefore it is inconceivable, my Lord, that this court would entertain the application brought on several grounds, my Lord, including grounds challenging the suitability or otherwise of the Deputy President nominee. My Lord, lastly, and because my learned friend will submit further, once a court has delivered a ruling, my Lord, the justice of the cause is that consequential processes can be undertaken given that there are no orders in place. And that is not for the court to be part of or to control. That is for other parties, probably not before this court, my Lord. My Lord, what you have done is dismissed the application conservative order. So that's a negative order. The court cannot be invited to review or to stay a negative order that has dismissed an application. And the negative order again goes to the application by Kimotho and Company Advocates from Kerugoya, who has also sought to stay your orders, yet all that application had, my Lord, was for the former Deputy President, former underlined, to apologize to NIS. Surely, Kimotho, you can do better. My Lord, I'll invite my learned friend to go.
You are protected. You are protected.
No, Mrs. Kimotho and Company.
Yes, my Lord, my name is Muzomi Tenkolu for the second interested party. I have listened very keenly to the two applications, and the issues for you to weigh in your mind are as follows. One, if the outcome they seek through these two applications was declined by the Court of Appeal, not yesterday, but today morning, can this court, being a court lower than the Court of Appeal, on the very same day be seized of an application that result in the very outcome?
Your Lordship, may I kindly bring it to your attention that counsel has a duty to this court to speak the truth. Being an officer of this court, being a doctor and a teacher of the law, he understands the duty that he has towards you and towards the law, and the fidelity to the law. It is not true that an application was dismissed. It is true that parties were told to serve. So let him submit on the premises of facts and not the premises of presumptions and with the intentions to mislead this court. And if it was declined, let him bring the orders.
My Lord, I think it's an issue of semantics. I come from a community that is not an expert in the English language, but whatever you call it, the point is this. The effect of you granting either of the two applications would be to contradict a decision by the Court of Appeal today morning, not to grant similar applications. That cannot be denied in good faith.
We are objecting to this. They are misleading. I was before the Court of Appeal.
As you were in a car in the morning.
My Lord, the Court of Appeal is a court of record. I don't want to belabor this point. Let me move to my next point. The Court of Appeal is a court of record, and I'm sure the court has access to that record. 2, my Lord, it is not like Kindiki was nominated yesterday or the day before yesterday. He was nominated several days ago. If the applications now being made were made in good faith, they should have made a formal application several days ago, which would have been on record, which we would have had the opportunity to respond to. You are now being invited by submissions from the bar without a formal application to grant some relief, supposedly on the ground that Kindiki is unsuitable. That cannot be proper, my Lord, especially when the nomination of Kindiki wasn't made yesterday or last night. They had noticed for several days. If they have any issues with the suitability, they would have filed an application on that regard, or even amended the applications we just determined, and they were granted that leave, and they didn't amend them. So surely it's an ambush for my colleagues now to stand up and start telling you Kindiki this, Kindiki that, and therefore stay, and therefore Matthew paper this and that. 2. Number 3, my Lord, what you're being asked to do is to flip-flop or to behave like a pendulum. My Lord, a pendulum moves from this end to the other end, but it never leaves the two extremes, so there is what I usually call motion without movement. The court has already read a ruling to us saying that it cannot issue a conservatory order that would have the effect of suspending any provision of the Constitution. You're being invited right now to do exactly what you have just told us cannot be done, and you're told the reason you should do that is because you're human and there is a possibility you're in error. Of course there is a possibility, my Lord, you're in error, but there is a court that exists to correct errors made by this court. You're being asked to embarrass yourself to say just a few minutes ago that the conservatory order should not have issued in the first place, and then you're being invited to issue an order that would have the contrary effect. I think they are setting up the court for embarrassment. My Lord, there is a reason, there is a law which we all know because both the people in the bench and the bar are lawyers. And it is common ground that no appeal operates automatically as a stay of any decision made by any court. The reason that rule exists, my Lord, is so that whoever is desirous of an appeal can move the appropriate court, which they have done, and persuade that appropriate court to issue that stay. So they are telling you because there is a possibility you might be in error, therefore automatically. But the rule, if I understand it, is that no appeal, let alone an intention to appeal, can issue automatically. Lastly, my Lord, you have been told about a Madhu paper, injunction. I thought we were talking about conservatory orders, my Lord, because Munya told us injunctions are remedies in the realm of private law. They exist to protect personal private interests, and conservatory orders, which you just said cannot issue in the circumstances of this case, are the remedies available in public law for the ordered functioning of public agencies. And because, my Lord, I said this court has jurisdiction, if eventually you find that the Honorable Brigadier Gachagua was not lawfully impeached, this court has still confirmed it has a remedy. It can undo the entire process. Let us not detain you here, back and forth, flip-flopping, behaving like a bedlam. It is holding the court at ransom, in my view.
My Lord, if I use use only 2 minutes in rejoinder with the
After
court
that,
permit me.
you will respond after Peter.
Yeah. My Lord, I'll just take 2 minutes to mention something which will be in addition to our case. My Lord, Article 10 of the Constitution outlines the doctrine of rule of law. My Lord and my Lady, the doctrine of rule of law anticipates that at some point controversies in the society, especially legal controversies or controversies related to the interpretation of the Constitution, will be determined by judges. And concomitant to that is the doctrine of finality of your decisions. And more importantly, the public policy in terms of consistency in judicial decision making. So my Lord, my Lady, once you've made a decision, the expectation of the public is that you will stand by that decision unless there are exceptional reasons for you to depart from that decision, especially immediately after you've rendered your decision. It will undermine that doctrine of finality of judicial decision making if you immediately depart from the decision without exceptional reasons. They have not put on record exceptional decisions to warrant that immediate departure, and the public expects that your decision will be enforced. Secondly, the doctrine of rule of law again operates in a complete way. John Locke in 1689 developed a concept in his treatise of government known as the concept of inalienable right, which informs our constitution. And one can mention here that judges have a right to be wrong. They say you have a right to be wrong. We have listened to your decision, and we believe that the reason why conservatory orders cannot be continue is a heavy public interest reason of the need for the vacancy, for there to be no vacancy in the office of deputy president. And the Constitution does not anticipate that. So in conclusion, they, under the provisions of Article 164(3), they, based on the way the rule of law works to model the fabric of the society, they have the right to appeal. My Lord, you have granted that right in your ruling. And from where we stand, we submit that they cannot, on this matter of immense public interest, where you've made a decision, for them to seek, to make an application from the bar, to upset a decision which you have rightly pointed out is meant to fill a major constitutional gap in respect to vacancy. And lastly, the right to be heard. The right to be heard is very central. Mr. Ndegwa has made factual statements in this matter in his oral application. Again, given the immense nature of this matter in terms of public interest connotations, it is important that the respondents are given opportunity to specifically rebut the factual questions of law, the factual questions and some of the legal points that they are brought up. So in that case, if they really want to move this court, then we will submit that the proper way is to make a formal application so that we are hard on that question. Thank you.
Your Lordship, the IEBC, the second application was directed at us. Everyone seems to have said something except the IEBC. And I just want to make two small points. Number one, as it relates to the application by Mr. Ochiel Dudley, my friend. First, Madhu paper was pre-2010 constitution. That is important for the court. It was a commercial matter relating to restitution. So it was a remedy in private law, not in public law. Lordship, Madhu paper was pre-2010 constitution. It was a commercial matter, a restitution in private law. So this will not apply. The second issue, application by Mr. Ndegwa, Learned Counsel, I am looking forward to reading the decision of the court, because those were issues that we were on our feet for 30 minutes arguing about, the role of IEBC and what needs to happen. So already the court has made a decision on that, and likely the answer will be in the ruling that the court has already read. Third one, and most importantly, I want to point to the court the case of Eliud Matindi and two others versus the President of the Republic and the PSC, E084 of 2023. It is the CAS matter, and it feels almost like deja vu that Ochiel Dudley is here making this point. We lost that matter in the High Court. The court made a finding that the offices of CAS were not constitutional office. We were on our feet for a long time trying to urge the court to give us a Madhu paper injunction. And the court said, if the issue related to constitutional compliance or constitutional infraction, as the court has already noted, that the position of the Constitution must remain operational from the decision of this court, then that injunction will not apply. The remedy is for the parties to apply to the Court of Appeal for an appeal or a review of that decision. So those three things can clarify those two issues for the court. We think these applications are not merited, and the court and the parties should put more effort in their 5-2B application. Thank you.
Perhaps before senior speaks, maybe we get directions as to how many they are responding, because there was that limitation on this side, and we were restricted as the petitioners. If the court could give directions as to that.
Let Mr. Moses speak.
Thank you, my lord.
My lord, but you have not given us directions as to how many of them should address you, considering that the petitioners were restricted.
We said two. 3 of them have already spoken.
My lord.
Mr. Moses, nothing stops you from saying that you adopt the position of your predecessor.
That's correct.
Yes.
My lord, I want to say that I associate myself with the sentiments by my colleagues, but I would want to add, my lord, that you have given a detailed and a very comprehensive analysis of your ruling. You've gone into graphic details, and you have addressed various issues and given a determination on the same. We are not before this court, my lord, to litigate in installments. My learned colleague, Mr. Ndegwa, has all along been aware that Professor Kindiki was nominated. For him to just spring up now and start raising issues concerning Professor Kindiki is just but a mockery of the justice system. My lord, you've made a determination. You have thanked us official. We will not want you to reopen these proceedings again. They have known and available avenues to them. Let them proceed on those avenues. I submit, my lord.
Thank you very much. On only one point, which I actually objected to when it was being made, the point was that how would Kenyans receive the decision? I'm not so sure whether this is what these applications should be based on, because whichever way, there will be parties that will be aggrieved by the decision. There are many others that will be satisfied. Do not be misled that there would be protests, just the way I also cannot mislead you by saying there will be jubilation and celebration everywhere. The position remains, the court has rendered itself in a decision, the court is thanked us, and therefore we have now to move on. Any party aggrieved knows what to do, which is either to appeal, apply for a review, variation, or whatever it is they have to apply for. If the processes that will take place after this would be contra the Constitution. Every party knows what to do, and this court is still seized of the matter, and they will be coming over here for a pronunciation on what the constitutional rights are. Therefore, we should actually not be taking the route that the decision may be popular or unpopular. It's a decision of the court, and it cannot be challenged along those lines.
Thank you. My Lord, honoring the court and my colleagues' time, this is my rejoinder in exactly 2 minutes. My Lord, Rule 32.2 of the Mutunga Rules allows us to make this application informally as we make it. Rule 32.2 of the Mutunga Rules allows us to make a Madhu paper application as we do. It says the application can be made informally immediately after delivery of the judgment. Rule 32.2 Mutunga Rules. My Lord, this President, the Attorney General, when on the other side, has many times sought a Madhu paper injunction. In the Finance Act litigation, where my friend Mr. Somane was present, Justice Majanja presiding, this court in this room issued a Madhu paper injunction. My Lord, on the last point, my learned friend Mr. Ojenda sounds familiar with the Madhu paper case. It's a Court of Appeal decision. And you saw the first one, Bat versus Rent Tribunal. It is one of the most cited cases on the question of stay. And in that case, the Court of Appeal said, my Lord, allow me to read, and then I'll sit down. There is no inconsistency in granting such an injunction, a Madhu paper injunction, after dismissing the motion. The purpose of the order is to prevent the Court of Appeal's decision from being rendered nugatory, should that court reverse the High Court's decision. The respondents concede that you could be wrong. There's human infallibility. The purpose of the request we make is to respect that issue. What if you are wrong? And you allow the wrong person to come into the high office you've just established. My Lord, allow the request for 7 days. Thank you so much, my Lord. And my Lord, may I just clarify that our application is distinct. We do not seek stay, we seek an injunction. Thank you.
And I'm interested in the event, my Lord, it's allowed. Can we also move you again to remove it?
My Lord, I think in view of Article 50, they also have a right to make that application. Your Lordship, allow me to draw your attention to Article 149, Clause 1. That London is not burning, and that a vacancy is contemplated, and actually a vacancy of 74 days, within which due process ought to be initiated to ensure that a rightful person, fully qualified, fully known in law, fully appreciated by the law, takes over office. Therefore, this vacancy is a constitutional vacancy. Further to that, Your Lordship, permit me to address you that this is a new application, and this application has not been determined. Further, allow me to indicate that I listened pensively to the 3 thematic issues that were raised by the court, and this is not one of them that was raised and resolved by the court. Finally, Your Lordship, we all have a duty to uphold the law and to defend the Constitution. On the 16th of October 1953, Fidel Castro had this to say in his defense, that history will absolve me. History will absolve the petitioners. That we have brought to your attention that you have the duty to protect the Constitution, that the person qualified should take over. I'll wait for the ruling. Finally, Mr. Somane has not addressed you on the qualification and the ability of a person to meet those qualifications under Article 99 and Article 137. He has not even told you that they are not applicable. If the court want to say they are not applicable, history will absolve me. If the court want to say that has no power to defend the Constitution, history will absolve me. If the court want to pave way and mutilate this Constitution, history will absolve me. If the court want to midwife an injustice, history will absolve me. I am most obliged.
My Lord, Sam Nyaberi for the 9th petitioner. Only 2 issues. I invite you to Article number 23 of the Constitution, which gives parties rights to come before you.
Article
23 of the Constitution, which allows parties to come before you to seek for reliefs. And in this instance, we are seeking an injunction by way of a stay, albeit temporarily, of the orders that this court has issued. And we are not seeking these orders in eternity. We are moving into the appellate court once we have the ruling. Number 2, my Lord, I invite you to the application by the 9th petitioner, the notice of motion application dated 18th of October. Because there was an allegation that we have been sitting here and it's coming as news that Professor Kithure Kindiki has been nominated to take over the DP position. My Lord, that notice of motion application speaks to the application they were making, that it was seeking for a conservatory order, and the court has rendered its decision. So we are inviting you kindly to exercise your discretion so that we may have that application processed before the appellate court if it is found of merit, so that we don't have to have it as an academic exercise. Thank you, my Lord.
May it please the court. My name is Dr. Iboso, and my co-petitioner had made a similar application that the Honorable Court, be pleased to stay the order that it has given today. And the respondents have raised an issue that Professor Kindiki was nominated over a week ago, and that if we were raising this application in good faith, then we ought to have raised it earlier. I wish to refer the court to its directions, which made it clear that one, the only applications it was going to hear were the 2 applications that were before the court, and this was made despite protests that my co-petitioner and I have raised for the last 2 weeks, that we have applications that seek similar orders and they've not been heard. However, I also would wish to direct the court to its own directions, which directed that we file amended petitions because many of the petitions had been overtaken by time. And if you look at our petition as amended, we actually raise concern about the process of election of the deputy president designate in our amended petition. And so it is quite in substance and whatnot. Secondly, I'd like to point out that my co-petitioner pointed out that we have been feeling discriminated. And as she explained earlier, she's dyslexic, and sometimes she might rush her words, especially when she's tense. The feeling of discrimination that we've been having is that out of all the petitioners, we are the ones who have consistently for the last 2 weeks called on the court to refer to the applications that are before it, and that which touch on this, and we be given adequate time to ventilate them. Yesterday, I agree we were given an opportunity to speak as interested parties, and after the respondents gave their case yesterday, I tried to catch the attention of the court, and I was ordered to sit down. I wasn't rising because I don't know I don't have a right of response. I know that. I was rising because I sought the discretion of the court, specifically because there are specific 4 issues that the respondents raised against the things I had raised. And in the decision of the court today, which I have listened to, one of the issues has actually turned on that. The fact that this court believes, which I believe is wrong, that it has jurisdiction to reverse the assumption of office of the Deputy President. Of course, you've given your ruling and we respect it, and we wish to appeal that ruling. However, now we are asking the court, because both the respondents and us applicants agree that we have moved the Court of Appeal, and the Court of Appeal has given a mention date. So the court is aware of that, or at least that is not disputed. We are asking the court to stay its decision today, allow us to move the Court of Appeal appropriately so that it can give the necessary orders as relates to that, even if it means correcting what we believe to be the wrong finding of the court. The idea that this court is functus officio does not arise, because the rules of the civil procedure, I'm not sure which rule exactly it is, allow any court, after giving its judgment, allows a party to ask for a stay even informally and the court to grant it. So really, the issue of functus official does not arise. Thank you very much.
Thank you. We will adjourn for 20 minutes. We'll be back at 5:30.
Excuse me.
All right, there you have it. The rulings by the High Court today is that the court has cleared the path for that is Deputy President nominee Kithure Kindiki, of course, not vacating the orders, but initial orders staying the swearing in of the Deputy President nominee, that is Kithure Kindiki. So as it stands at the moment, Deputy President Rigathi Gachagua is actually impeached, and of course we want to get to understand on this particular ruling, and of course we've been able to see the petitioners actually putting a defense, trying to have the courts actually issue new conservatory orders that will prevent the swearing in of Kithure Kindiki until most of the issues that they've been able to raise in terms of whether it was constitutional for, or rather the legality aspect of it in terms of appointment of Kithure Kindiki or nomination of Kithure Kindiki is concerned. Now, Robbie, let me start with you, or rather, let me start with Kimani here on this particular ruling and what we make of it to some extent. At what point did we notice that it was actually going to this direction for you?
You see, what has just happened is that the three-judge bench has set aside the conservatory orders that one had impeded the impeachment, the swearing in of the Deputy President nominee. And with that now, we have a green light to go on and swear in the deputy, unless the application sought by the petitioners is again held by the court, and now the court has again to go back on its own judgment and allow the stay to the order. So it's a funny one. We can only wait because it is not yet done. So, I mean, minutes ago, we knew that the deputy president nominees, the way has been cleared for him to be sworn in. But as it stands now, the petitioners have also made some applications, which the judges have asked for time to go think about. And you see now the other side has also made its remarks on the applications. So we wait for the judges to come back and tell us whether the judgment they gave a few minutes ago stands, or whether they are going to give a fresh orders, again staying their own judgment.
And on the issue of staying their own judgment, before I let you go, I think it will be interesting, because I think when we are following that, we've been having a conversation here to try and determine whether that's a possibility or not. What will that speak to the judicial process itself, if at all the prayers by the petitioners are actually granted by the courts?
What I like is that we've become of age as a country, and especially judiciary, that we are here having a decision made by the judges, and that the court has to entertain application to be done informally, and that it has to be listened to, and a decision made again on it shows how far we've come as far as entrenchment of law and democracy as a country is concerned, which is a very commendable thing. That even justice must not only be done, it must also seem to be done, so that the judges, people are not left with an opinion like the judges are prejudiced. Because, you know, it is only in the court of law that you should find an prejudiced mind adjudicating your matter. In the Senate and the National Assembly, you can rest assured that that is purely political. If they have political scores to settle with you, then your goose is cooked. You can't go to court and find the people who are prejudiced against you, and that they can make judgments in a way that is prejudiced. So it is a clear indication of how we've grown as a country as far as legal matters are concerned. Yes.
All right, Kimani, I'll have to release you at the moment. So thank you so much for your time and being here on set to try and make sense of what has been happening today as far as the corridors of justice are concerned. Robbie, let me come to you. In terms of interpretation of what has happened today, or rather what is happening, because now we just adjourned for for close to 30 minutes, then we'll be back and, you know, see whether the prayers that have been asked by the petitioners are actually granted as far as staying the orders, the same orders that have been granted by this particular court. What happens in this particular case, or what do we read of this?
Now, I would like for people to understand what was coming up today before you judge the judges on what they are doing, because they have made it very clear on the issues that they were coming to determine, or rather what the ruling was coming to determine. They had to make a decision on whether the High Court, as a High Court, has the jurisdiction to hear matters of impeachment of the Deputy President, or rather that is a preserve of the Supreme Court. You will remember that disputes arising from a presidential election are solely a preserve of the Supreme Court. And that was the same trajectory that was being taken, that if presidential elections are being treated to the jurisdiction of the Supreme Court, then the same way anything to do with president's impeachment or his deputy should be done by the same court. But they had to give a clear indication that will set the pace for even next impeachments to come, on who actually has, where do you take disputes over an impeachment process. And they have decided, they have made it clear that that's the High Court, that's the purview of, or the original jurisdiction of the High Court under Article 165. Now, the second thing they had to deal with was or determining whether the petitions that have been brought or the impeachment thing is a political question. And being that there's a doctrine, they're calling it the doctrine of justiciability, that the court cannot adjudicate over a matter that is purely a preserve of another arm of government.
Okay.
So that, like, if the executive is doing policy formulation, then the court cannot direct the executive on how to do that policy. It can only say that the policy is not within the constitution, but it cannot direct the executive on how to do policy formulation. If there was a specific constitutional provision saying that the impeachment, the decision of the Senate in an impeachment is final, then that would not be a matter to be adjudicated in court. And they have gone back to look at our constitutional process way back from 1963 and noting down that it has been the intention, if at all we wanted all this to be the decision of the Senate, or we wanted this to be adjudicated at the Supreme Court, then there was nothing stopping the drafters of the Constitution from putting that provision in the Constitution. And since they did not, the Constitution actually contemplates such a situation where you will have a court matter that is not provided for in the Constitution. And those are the preserves of the High Court. So it has ruled that the impeachment process is not a political question, is not limited by that doctrine of justiciability. So you can't say that the court cannot listen, because the court is here to listen to issues of infringement of rights and issues of due process and the constitutionality of the impeachment per se. It is not there to adjudicate on the charges that were given to Gachagua and for him to defend himself in court. The court is only there to listen to whether this process followed the Constitution, whether there were rights infringed upon during this process, and whether the Constitution upholds what was done. Now, the third and the last thing now is what Kenyans had been waiting for, is on the issue of the conservatory orders. Now, there are two things. The petitioners, Rigathi and the fellow petitioners, had made an application for conservatory orders to issue from the three-judge bench. Then number two, there was also an existing conservatory order issued by the High Court at Kerugoya. So the court had to determine whether it lifts the one from Kerugoya and issues its own, or lifts the one from Kerugoya and also denies to issue a conservatory order to as per the petitioner's request, and that is what has happened. But in our civil procedure rules, whenever you have a ruling or a judgment given in you have a right to appeal. And you can make an oral application in court at the point of after reading of the ruling or the judgment, and explain to court that you wish to appeal, you wish to lodge an appeal, and when you do lodge an appeal, you have the right to stay of these orders pending your appeal. Now, this ruling of this stay of orders pending appeal can be issued by the appellate court and can be issued by the same court that gave you the order, based on the public interest and the urgency of the matter. Now, at this particular point, the counsels for G have come out and said that we see this as a public interest matter and it is of great urgency, and there has been an impugnment on that, the deputy president nominee, and because of that, we are seeking to appeal. And when we do, we seek that the orders that have been issued today or that have been discharged today, or your ruling of today, be stayed pending our appeal. So that if the Court of Appeal makes a ruling to overturn what you have said, then it will not have undone your decision on making, because within that period, what we have seen with Kenya Kwanza, we are sure we might have a swearing in tomorrow morning if we don't.
Right. I want to get to understand a little bit, based on that particular ruling, and I have questions I'm going to ask you so that we get to be able to elaborate on that more. But let me come to maybe on the political front. You see, we have the Court of Appeal actually denied to grant them orders to conservatory orders for the hearing today and whatever was happening in the High Court to actually continue, because the petitioners do have a problem with the empanelment of this particular bench, because it was constituted by Deputy Chief Justice, that is Philomena Mwilu, and that was actually one of the issues that have been playing in the corridors of justice. The first ruling was a blow to DP Gachagua. The second one, of course, the Court of Appeal actually got to deny that. It's actually a blow to him again. And the conservatory orders here have been lifted, paving the way for Kithure Kindiki to actually be sworn in. And of course, I do understand that we are actually waiting for those 30 minutes before we get to understand whether we are going to have conservatory orders again preventing that particular action taking place. But you see, we have a deputy president in place that to some extent seems to be losing in the corridors of justice as the process actually continues. Politically, when you look at that, because what does that speak to you as a politician and, in the political front?
Well, it isn't good for a politician to go out and lose, whether it's in politics itself or it's in judiciary or it's in parliament. It's not good. We always, as politicians, you want to go for something and you want to get it done for you. But I suppose psychologically, he knew he's going in and anything can be able to be done for it. And especially when you talk to lawyers, they will tell you there is a loophole here. If we go in, we can make it. But it isn't good for you to go for anything and lose it anyway, as a politician. I think psychologically, he knows also that whether he wins or he doesn't win is really trying to show that he still has an interest in being a leader and that kind of a thing. So I think whether he wins or he doesn't win is looking for ways in which in the future, in 2027 probably, because sometimes this impeachment, it means that you cannot be able to participate politically in leadership again. So he may be looking how he can still be able to be relevant in 2027 and the years beyond, apart from just being a deputy president for the Republic for the time being. Because I know socially it is impossible for him probably to work with the president. So he may be looking how he can be able to preserve and conserve himself for future.
I want us to take a minute on that political implication, because now here we're done with city politics most. And moving forward, because you are, if at all what we are seeing will be the trajectory up to the end, and he does not get to come back to office, then he will stand impeached and unable to hold office again or participate in an election, all that. So what would be the political implication for him? Do you think, even if he wanted to be a political leader, he could still marshal troops to rally behind him?
You see, it is the law. Once you have been impeached, it's difficult. Actually, it's a law. I think our lawyer here will be able to expound on that. But politically, one of the reasons, for instance, why you don't want to go in and you are thrown out in an impeachment is because you may not be able to, you are kind of being declared unfit to hold office. So once you are declared to be unfit to hold office, which other office can you come in? So it's important whether Professor Kithure Kindiki is put in as soon as possible as a deputy president. What the former deputy president is trying to do is to make sure that he's cleared, even if he doesn't get to be a deputy president, is cleared so that he can be able to hold other offices. Yeah, so it has got implications on himself. Secondly, by the time you go through this, you are also looking for sympathy votes, or people, the public are saying, oh, this our deputy president has really been persecuted. So there is also sympathy from the public. Okay. Yeah.
And Robin, I'm not going to ask you a political question, but on matters
I wanted to ask. I wanted to answer just to catch on what you had asked her, and as lawyers, we tend to be students of history by default, and we like reading from what has happened before and predict the future from it. Now, from the ruling of the court today, there's one case that they mentioned, and I think escaped many people's mind, and they mentioned the case of EFF versus the National Assembly of South Africa. And it was a case that was involving the impeachment of Jacob Zuma, who was eventually impeached. He did not resign. He continued to fight his impeachment. He went to court. He was given summons to come to court. He failed to appear in court. He was jailed for contempt. And after all that, in the last election, he shows up, he makes his own party. He's impeached. He can't vie. He creates his own party. The party focuses on just one province, KwaZulu-Natal, where he comes from, and his people, and they all vote for him as a bloc, and now he's officially the opposition leader of South Africa as we speak. So from my point of view, I don't see the failure of Rigathi from a point. I'm just waiting for when he says, this is my political
and
party.
That is what I think that's what I wanted to do. That has been a question that I think I've been battling with in terms of, because we are looking at political implication and how this might give him political mileage. Because we know if at all he goes ahead and, you know, does not, he's not reinstated, then he will be an impeached deputy president, of course, cannot hold office. Yes. The question I asked her, is he at a position now to marshal a region or the people to actually rally behind him, not because he wants to be a leader politically, elected in office, but to just have a say on politics in that, you know, in the country?
Now, I again will return you to history a bit and tell you that one President Uhuru Kenyatta vied in 2002, and the people of the mountain did not support him, and he lost to Mwai Kibaki. But come 2007, while he was the opposition leader, he did not vie for president. He chose to support the then president and be under him. And then we had the unfortunate incidents of the post-election violence, and he was singled out as a suspect by the ICC for quote-unquote what they termed as defending his people in the rift during the wars. And that alone was what propelled him to accede to power in 2013. Now, if you look at that case, what Rigathi Gachagua is being impeached on is that his politics of standing for Murima and talking about Murima is a divisive thing and is not bringing about a national image. And so for that reason, he cannot hold the office of the deputy president. So he fights it so that to the people of the Murima, the ones that he has been speaking about, they will rally behind him. And what that does, as I have explained with Jacob Zuma, is that it gives him that political mileage. Because what we have with our constitution is that we have given political parties a very large negotiating room for any government that comes into place. Our current Speaker of the National Assembly was the party leader of Ford Kenya prior to August 2022. Our current Speaker of the Senate was the party leader of PA prior to the elections. Our current Prime Cabinet Secretary had his own party. Our former CS for Trade, Moses Kuria, had his own political party. And what that has made, or what has shown and what has come out during the hearing, is the power or the authority that you having a party gives you in any government that is formed. What gives Raila Odinga leverage when he meets with all these presidents and helps them is because at the back of his pocket he has ODM, and he will do that. So if Rigiji was to kickstart his own political journey with a party, or maybe reunite with Uhuru and forge his allegiance to Jubilee, that would create a whole new shift on the politics of 2027 and the coalition agreements that will come from here.
Okay.
Yes.
Mary, as we finish on the political front, before I now take a look at detail on what has happened in the corridors of justice, what would that look like? Will it be a force to record with, or as we
I don't know. Maybe I'm not qualified to advise, but I think the Murima people, they better start looking out of the box for national, especially things that partake to national issues. It is very important for them not just to look inward to themselves, but they should look vis-a-vis what is happening to the rest of the country. Okay. You can see that the former deputy president, Gachagua, really was voted out by the rest of the country except Central. And with all due respect with the Murima people, it is important for them to know they are the only ones who make this country. So if we are going to move forward to forge a national outlook of the country, we must bring out people who have a national outlook to life, not people who are just looking and in a very interesting way where they don't care as long as it's I, myself, and we. So I'm thinking, well, it can look like the KwaZulu thing, but what it is, I don't know about the constitution of South Africa. This constitution, I was part of the constitution making. And what I know is it prohibits you, if you are impeached, it prohibits you to hold a public office. So he can only become very influential on who becomes the kingpin of Central, but not necessarily holding a public office. And I think that is what he's fighting for. Okay. That's what the former governor of Kiambu, what is Waitito, His Excellency Waitito, the one who was also, that's what they were fighting for. That's what Mike Mbuvi, the former governor of Nairobi, was fighting for. So I would beseech our brothers and sisters, we are a country, so that we don't set up the country on a trajectory of divisiveness, where we go in, because let's say, for example, the people of Central go that way, the people of Coast go that way, the people of Western go that way, then we don't really have a country.
But I beg to differ in terms of how we normally vote and how we play our politics. And yes, even when somebody says, this is my stronghold, we'll normally look at your backyard in terms of where you come from.
This is my bedroom.
Yeah, this is when
but that's what I'm just saying. This thing
so it is not necessarily it hasn't started with the
but does it have to go on because that is how we do?
Why?
That's why I came out from the very beginning. That's why I came out from the very beginning and said the country, we have to look at these things from a different perspective. I'm expecting, I have no problem with Professor Kindiki becoming the deputy president. He's from Murima still. I know, I hear now there is the East Murima, West Murima. But what I'm just saying is we have to come out of this country and make national values that of unity, of no corruption. You know, let's institutionalize good values and systems, so that when I look at Professor Kindiki, I'm not looking at him as a Meru. I'm looking at him as a deputy president for the Kenya, such that when he goes to Western, he does not need to go with Musalia to introduce him. He can still be able to go to Western and be welcomed as a deputy president of Kenya. Okay. If he goes to Nyanza, the same. So I'm saying, okay, it has always been, you have to have somebody backing you up. And I'm not saying that I'm reading the book of 2nd Chronicles, and I'm finding even David had, in his choice of people, he had his people who are named as from the Judah, the tribe of Judah. And it's not unbiblical, it's not evil. But what we are saying is, can we look beyond what and become a nation? Because we have never really been a nation. Okay. We a nation are a people who have got the same aspiration, they have the same language, they look at the future in the same way. We as a country, we have never reached that. Tanzania has reached that to an extent. But we as a country have never been able to reach that. And the much, I thought the much I grew matured a bit, it would cease. I just find it is again coming in even more louder and so on. So I'm saying.
So what would you say is the reason as to why we never got
It's
to
because
that
of the foundation. We were, from the very setting up of this country, we became very tribal. And then with the killing of Tom Mboya in 1969, again became very more tribal and oath-taking and those kind of things. And I think Mama Ngina and Uhuru were trying to bring us out of this by befriending Raila. But I think there are some people from Rima. Sorry, I'm a Christian, so I'll talk it. And I'm a student of literature and a student of this country. We are still going back to those oathing and so on. Let's come out, let's impress each other as a nation. Let's become a people that truly love one another.
Right,
and that's what I'm just saying.
Okay, okay. I want us to go back to what was happening in the corridors of justice. Let me bring you in on this. The Constitution, from what no one suffers harm if the Constitution is operational. This is what the judges actually did say. Looking at both sides of the divide, because there was an argument that the office of the Deputy President would remain vacant if at all, if at all there's the orders
as subsisting.
As yeah, exactly. And if Rigathi Gachagua did argue that if the court goes ahead and you know, allows Kithure Kindiki to actually be sworn in, then he's going to, you know, be the one that is on the receiving end when it comes to unjustifiable, if I call it that. But how do we draw the line here if I say the operationalization of the Constitution with both sides of the divide? How do we measure if this Constitution is operational at the end of the day? Because one side will always get to suffer.
So anyway, so when the court got to interrogate the matter of the conservatory orders, again it divided them into three issues on what it needs to come out on. And one of the issues on that was on public interest and where public interest lies with regards to this matter. It was the court's interpretation that the public interest on this particular matter of the impeachment of the Deputy President lies with operationalization of the Constitution. And according to them, they took us to, again, through the Constitution from the Independence Constitution, and said that you would notice that in the beginning, we had a vice president. Yeah. His role was being the principal assistant of the president, and he was working under the mercy of the president. Yeah. And when we came about to have a new constitution, it was imperative for Kenyans that they needed a president, they needed a deputy president who would not be tied to the president, that even if the president did not assign him any roles as his principal assistant, he still had some constitutional roles to fulfill. So you would notice the deputy president used to chair meetings for the IBEC. The time he was saying, hata mkitutoa nguo mtupige hatuna pesa. Everybody remembers that. That was part of doing his constitutional function that does not rely on being assigned from the president. If he was to attend a cabinet meeting, that would be just doing his job. And so when he was arguing on getting conservatory orders, he was saying that if you do not give me these conservatory orders, then I would stand to suffer irreparable harm, and I would not be in office. My rights would have been infringed. And that is when the court would come and say, by virtue of our constitution, the constitution now recognizes the deputy president as an office that does not hold another state office. You see, for the previous vice president, you are both an MP and a minister for home affairs.
All right, I'll have to stop you there because now we want to cross over back to the national to the Milimani law courts, where let's listen in to what the judges have to say as far as the prayers by the petitioners are concerned.
Thank you, Presiding Judge. This is the ruling on the applications. 3 applications were made before the court, The first, a Matthew paper injunction by learned counsel, Mr. Dudley Ochieng, and 2 applications under Rule 32 of the Mutunga Rules for stay pending appeal made by counsel Mr. Njiro and learned counsel Mr. Nyaberi. The applications seek an injunction and stay of execution of our ruling pending formal filing of an appeal before the Court of Appeal. The applicant submits that despite the ruling that has just been rendered, Rule 32 of the Mutunga Rules accords this bench jurisdiction to issue the orders sought, and that there will be no prejudice on any party. They further contend that the Deputy President nominee has not been vetted by the IEBC, which is in any case improperly constituted. In response, the applications have been opposed on the grounds that the court is now functus officio, having already rendered itself on the application for conservatory orders, that the Matthew paper injunction is not a proper remedy in the circumstances, that the Court of Appeal is now seized of a similar application that is for stay, and that this application should have been made earlier, noting that the nomination of the Deputy President designate was made previously. We have carefully considered the applications and responses, and in our considered view, our ruling that has just been delivered addresses these issues succinctly. Not only has the bench gone into great strides to explain the consequences of granting conservatory orders, which is to cause a de facto suspension of a section of the Constitution, we have equally warned against such a practice. To again turn around and grant orders whose effect is the very suspension of the Constitution that we have stated will, in our view, be an absurdity. We further note that some of the arguments that have been raised on the floor will form substantive arguments at the main hearing of the petitions. In any case, since the Court of Appeal is already seized of the matter, as we have confirmed from both parties, from both sides rather, the parties have an opportunity to move the Court of Appeal accordingly. As such, the applications are all hereby disallowed. Orders accordingly. And before we pen off, just a point of clarification on the other issues that were raised by 2 petitioners, Dr. Eboso and I believe your co-petitioner. If you are able to access this ruling, the ruling of today on CTS, you will note that disposition number E states that there will be a mention for further directions on the way forward in respect of pending applications and pending petitions on the 7th of November at 2:30 p.m. in open court. We will address that pending application during that mention. All right?
My lords, we are obliged by the ruling, and have a good night.
My Lord, on behalf of the respondents, we want to thank you and appreciate the verdict of the court. Thank you.
Thank you.
All right, I think at this particular moment we can call it out and say Deputy President Rigathi Gachagua stands impeached at the moment after the courts actually disallowed the applications by the petitioners when it comes to seeking conservatory orders until they appeal this particular matter, or they appeal this particular matter at the Court of Appeal, trying to stay the orders that this particular court has actually, rendered this afternoon. Now, let me get your final remarks on this particular matter. Did we see this coming? Let me start with you, Robbie.
Yes, I would say we saw this coming because in the ruling of the court, when they were making the ruling for conservatory order and saying that they should lift the ones for Kerugoya, the judges were very clear that what the conservatory orders did or were in fact doing was stopping the operationalization of the constitution. That by having a conservatory order to stop the swearing in, you are actually stopping suspending the constitution. And nothing can be worse than purporting to halt the supreme law of the land. And so when they were refusing to grant Gachagua conservatory orders and lifting the ones that are already existing, they had already pronounced themselves on that. So it does not mean that as counsel or as a person who is afflicted by the judgment, you don't have a right to make an application for stay. You still have that right. But for clarity purposes, the court will not stop you from making that application because it is provided for in law.
So what will be the next step for them if at all they needed conservatory orders? What happens at the Court of Appeal after this? So
if they at all needed to stop the situation, they need to file a notice of appeal at the Court of Appeal. But as has been rightfully put out, they had already made an appeal to the first ruling. So there's already a matter before the Court of Appeal on the same issues. So all they need is actually to raise a notice of appeal with regards to this second ruling and join it in that matter, and then now make a fresh application before the Court of Appeal to stay the orders of the High Court pending the determination of the appeal itself.
So, so what could happen at the Court of Appeal? The Court of Appeal could actually issue conservatory orders on the decision that we've seen today?
Yes. That nothing stops the Court of Appeal from staying the ruling of today. Nothing stops them from actually overturning the whole ruling, because even the first ruling, the one they keep on referring as ruling number 1, is subject to an appeal process at the Court of Appeal.
There's still a case, you know, the case itself, of course, we know it hasn't started. Yes. So with all this, you are the High Court or the Court of Appeal. How do you balance all this?
So eventually all these matters will end up at the Supreme Court. We can already foresee that. At the end of it all these matters will end up at the Supreme Court, just like the BBI case, just like the cases before the Finance Act and all that. But before we get to that point, there needs to be I would say, catalyzing of issues. Okay. Because even if you approach the Court of Appeal, you have to approach the Court of Appeal with sufficient grounds, with specific grounds. And now those go again, cutting down the issues to specific things.
There was you know, a decision that was made in terms of whether, because the petitioners argued that if at all you go ahead and lift these particular conservatory orders, then you are going to see Kithure Kindiki sworn in as deputy president. Then you know, when we now start listening to the case, the hearing begins, and we get to a point where you figure out that the process that was done at the National Assembly and maybe the Senate was not properly done. Then again, it will be, you have to make a ruling to get to reinstate Rigathi Gachagua, which with Kithure Kindiki already in office. And the argument that the court had put out was like, you see, the petitioners argued that we have a government that does not, you know, follow court orders. So they might actually refuse to follow that particular court ruling, if at all that would come. And the court did say we cannot, you know, assume that that will be a possibility, because we have a mechanism in how to ensure that actually court orders are followed. So if in any chance that will happen, that we have a deputy president, the deputy president-elect sworn in and assumes office, and when the process of hearing this particular impeachment case begins, and the courts now find that Rigathi Gachagua was not accorded, you know, proper procedure when it comes to his case, and make a different ruling in terms of reinstating him. What happens in that particular case legally?
Legally speaking, the deputy president, that is then Rigathi Gachagua, will have to assume office, and the court making the decision that the process was flawed has a mandate to make an order directing the current holder, if they have sworn in Kindiki at that time, to pave way for Rigathi Gachagua to get back to office. As I had explained, it has happened before in Wajir. And if you listen to the ruling, they had actually got to a point and explained that there was a time the courts, the councils were trying to be crafty and saying there's no law on the procedure of this impeachment of a deputy president. And they said what has been applied in impeachment of governors will apply to this situation. We call it mutatis mutandis in court, but will apply to this. That's because you have not made legislation that clearly says deputy president. Does not mean the court will do this blindly. We are guided by what has been happening in the impeachment processes of the governor. So in terms of them making a decision that it was flawed, it does not stop them from, again, kushukisha Kindiki from office and telling him that Rigathi needs to occupy his office back. But that's, I would say it's a tall order, legally speaking, because what his counsels have done in court is they started in court by attacking the judges, the three judge bench, and asking them to recuse themselves. They refused. Then they were attacked with the issue of whether the court has jurisdiction or this should be a Supreme Court matter. Then they were attacked on the issue of conservatory orders, and the trajectory they have been taking is failing and failing, and it seems unlikely that at the very end you will get back. So what you only need to show court at this particular stage is that there's a prima facie case, that you have an actual case that can be argued in court, and the court has ruled that they actually do have a prima facie case. Then then you need to show what public interest your matter serves and the irreparable harm that you would suffer. Now the court has pointed out the issue I was talking about the deputy president having roles outside the designation or the mercy of the president. And they say that for as long as you call it the status quo, that we do not have a deputy president in office, it means those functions will not be performed. And that is an unconstitutionality in itself. A court cannot come and say, do not operationalize or do not perform the functions provided for by this constitution here. So by the mere fact of saying that, it means the Kenya Kwanza government is cleared to conduct a swearing-in ceremony as soon as 7 a.m. tomorrow, the same way they did with the chief administrative secretary.
Can it be that soon, though, in terms of looking at maybe if we go to the Court of Appeal?
In the words of the MP for Langata, Jalango, the way things are happening in this country, I want to say on national television, congratulations to Kindiki on your swearing in. Okay.
My last question before I seek your remarks here is the issue of IBC and what has been argued by the petitioners in terms of how Kindiki was cleared. And there's been that particular argument that IBC does not have commissioners, yes, but still the secretariat is there. So what exactly happens in this particular case? Is this something that holds water in terms of the clearance of Kindiki? Does what is happening at the Independent Electoral and Boundaries Commission, how it is at the moment, is it legally constituted to some extent to be able to carry the function of clearing Kindiki?
Okay, now to begin with, I want to point out that it is not only on the IEBC, but also on the Registrar of Political Parties, that he is cleared as a member of UDA, while he had to resign from any political party to assume the office of the cabinet secretary. Now, number two, on the issue of IEBC, the court in this circumstance, the three judge bench, was not dealing with the question of the suitability or the appointment of the new nominee. They were only concerned with the impeachment, or rather the unlawful removal from office of the previous deputy president. And that's how they have tried to stay clear, and they're calling it the principle of constitutional avoidance, because that matter is also pending in another court. There's a court that is dealing with the question of whether Kindiki is suitable to be in that office, whether the process within which he was nominated and approved by parliament was constitutional or was procedurally fair. So on that extent alone, I can dive into IEBC and point that one of the issues that has been raised is that we do not, there are 4 constituencies that did not have a member of parliament during that vote. And the only reason that those 4 constituencies have not had that vacancy filled is because the IEBC, for IEBC to conduct a by-election, the commission must be standing, must have quorum to conduct a by-election. Now, in these circumstances of approving a nominee for deputy president, it is assumed that that is an administrative role. But it is also a legal question on whether, since that is the work of, that is a prerequisite for an election, whether that is an administrative work or it is the work of the commissioners.
So the determination of that is going to be done by the court?
Because if it is actually, if we consider it from that point of argument that since IEBC is the commissioners have to be in place for an election to be conducted, then you cannot clear a candidate who would otherwise stand for an election if you do not have that commission. But that is an argument to be made in court, because we can also argue that for nomination of a deputy president, which is unprecedented and which was not fathomed, or as they put it, which was not contemplated by the constitution, then it falls barely squarely on just an administrative role, since he was previously the chief agent to the UDA elections.
Okay, and cabinet secretary, and because he's a cabinet secretary at the moment, right? But for you to be nominated for that particular position, deputy president, requires you not to be holding any other office. So where does that fall? Is that something that can also be raised in the corridors of justice as they continue to with the suitability of this particular candidate?
As it stands, for most of the stand that we had been taking in the argument on the IEBC commissioners, is because for you to be appointed or to be nominated for that position, you needed to resign from any state office. But unfortunately or fortunately for them, they did not. We have this issue with Kenya Kwanza government and leaders. They always do something in betting called double chance. They don't let go of one thing. They go with two legs. If this one works, okay, I'll take it. If it doesn't work, I can stay with this one, what I have. Case in point, the speaker vied as the senator for Bungoma, and we were forced to have a by-election there just to replace him, and he had negotiated for that office. So, and in the same sense, that is the undoing of Professor Kithure Kindiki. In my estimation and in my thought, I would have thought that before even the impeachment process was laid down in National Assembly, Kithure Kindiki should have resigned as the CS, taken up a position in UDA as in the executive committee, and waited for things to unfold before he actually assumes office. But also, as we say, the same way they were arguing that this regime does not respect court orders, they have their own way of interpreting the constitution and the law.
Right. Mary, if at all we go ahead and swear in the deputy president nominee Kithure Kindiki, and yet there are some questions that are questioning his suitability as somebody who's supposed to be assuming that particular office in terms of clearance by the IEBC on the issue of whether he's a member of, of the UDA, so what Robin has been able to put out, and also the issue of whether he's supposed to have resigned first before he was actually nominated. What will this then bring, to the country in general and just the political class?
For me, the country is going on. I think we would have had a constitutional crisis if there were conservatory orders, just like the judges have said. Since I know now the government will do it as quickly as possible. My brother has already said it's 7 o'clock in the morning, but I'm sure there is no constitutional crisis right now. We are going to wait for the former deputy president, what the court will say about his case, but the country now goes on. The most probable thing that I see is, according to the functions of these courts also, is that, in fact, it's a precedent that has been set, because constitutional issues, okay, we have a constitutional court at Milimani, but most of this would have been dealt at the Supreme Court. So with what has come in right now, we are just going to wait. Even if it goes to the Supreme Court, it will be, was the procedure you followed? Was his human rights were again violated, and that kind of a thing. So I'm not expecting much to change. So congratulations to Professor Kithure Kindiki as the Deputy President of the Republic of Kenya.
Okay. What would he have to do to be in the good books politically? Because to some extent we started calling the Deputy President seat, cast.
It is not really cast. It's what he will bring on the table. What I have already said, I think one of the problem of the former is being too murima. Let him become a national figure.
All right.
Yes.
Okay, national figure.
Let him become a national figure. Let him go anywhere in this part of the country without anybody to introduce him. Let's find out. I know Professor Kindiki because he has been a professor with me at some place where we've taught together, and he's a good man. I know if he puts his legs on, he can be able to make it very well.
Okay, that is something that we'll have to wait and see. We can take you out for that. Robin, final remark, 30 seconds. Direction, this country moving forward for me.
The direction moving forward for this country, I want to say it here live and direct. We said kufa dereva, kufa makanga. Makanga amekufa, bado dereva.
All right, that's where you wrap it up. Thank you so much for being part of this particular special edition and coverage of the impeachment of Deputy President Rigathi Gachagua, who is now impeached. Deputy President Rigathi Gachagua, after the High Court did vacate the orders to, not allow the swearing in of Kithure Kindiki. And as they say, of course, the petitioners already are going to the Court of Appeal to see whether this particular judgment will be stayed or not. And as we stand now, maybe the path to get now to swear in Kithure Kindiki is open until further information comes from the corridors of justice, with the prayers of the petitioners who are of course, lawyers representing, that is Deputy President Rigathi Gachagua. The hearing itself, of course, hasn't officially started when it comes to the impeachment process and what happened at the Senate with Rigathi Gachagua, right? My name is Brian Amuai. I do want to thank you once again for being part of this particular program, and on behalf of everyone that made this one a success today, I do want to thank you so much for watching. I'll see you again at 9 p.m. Do have yourselves a lovely evening.